really more of a search warrant. Anyway, we're going to talk about that. Hello, Towel friends on the Towel YouTube. How's everybody doing? I'm a little towel. And you may be saying to yourself, sir, we are very well aware that you are a little towel. Well, sorry, I just ate lunch. If you don't believe me, listen to the towel. Roll the intro.
Hold on. Wait a second. That's it.
That's it?
Yeah, that's the melody to Funky Town.
You heard the towel. Hi, Monica Nelling. Hi, Christina Towel. I'm a little towel. How's everybody doing? Hi, Artworks 2. It is so good to see you, my dear friend. God bless all of you for tuning in. I'm so excited to read these two documents with you. We got two documents, one in the Karen Read search warrant case, the ongoing 2025 investigation involving Karen Read and Aidan Kearney. And then we got another document in the civil case. It's the ruling, the memorandum in order on decision from the judge in the John O'Keefe family civil suit against Karen Read. We already had that decision. In principle, we knew what the decision was regarding Karen Read's 12B6 motion to dismiss, but now we have the full explication. I'm so excited to talk with you about it. Now, what else we're going to do? Here's what we're going to do. We're going to do a few things. One, we're going to read through this search warrant affidavit or search warrant motion from Karen first. All right, that's on the search warrant docket in Norfolk Superior Court. All right, we're going to read that. Then we're going to take 20 minutes to watch a video where I explain my position. Because a lot of people have been saying to me, Grant, what in the holy hell is going on? What do you mean you're backing Karen Read as to the ongoing situation with Aidan Kearney and the recordings? And what does this mean as to what you think about Karen Read in the night of January 28th into the morning of January 29th and John O'Keefe's death? And furthermore, what exactly does this all have to do with the larger picture of the integrity of our justice system? And why have you been yelling like a mad towel for the past 24 hours about how important it is not to allow Kate Peter and other people to wheel and deal and undermine the integrity of the justice system, and how that fundamental principle of conflict of interest is more so than anything else why I'm concerned. So I also don't like when women are taken advantage of or looked down upon, and we'll talk a little bit about that. But I have a 20-minute video from yesterday. I clipped a part that I think really explains how I feel, and we'll watch that as an intermission. Hello, Barbara and Lisa C. Thank you so much for the cheeseburger yesterday. I absolutely got a towel cheeseburger. It made me feel a lot better. Hello, Troy. Good to see you, dear friend. Troy was having the day of his life yesterday, ladies and gentlemen. He's never felt happier in the chat. But yes, we're going to read through these motions. As I mentioned, we're going to read through the first one. Going to take a towel pause to watch that 20-minute video, and then we'll go with the second one. All right, so let's begin. Let's begin, little towels, if you're just tuning in. This is the motion up from Karen Read on the search warrant affidavit. Now, if you want to figure out some context as to this search warrant, it comes from a January 2024 search warrant affidavit filed by then Detective Lieutenant Brian Tully on the basis of Lindsay Gattani and Natalie, the German, providing information to the state police. Now, I'm not a lawyer, this is not legal advice. Something you have to understand is there's a difference between a search warrant, a seizure warrant, and a search warrant. All right, the search and seizure are two distinct things under the Fourth Amendment. You can seize something without searching it. Okay, you can seize something and then get a search warrant later, or you can search and seize something at the same time. Now, we're just talking about plain search and seizure warrants. We're not talking about the exceptions or search incident to arrest or any of that shit. We're just talking about, any of that stuff. We're talking about a plain search and seizure warrant. You can. In this case, we had a seizure of Karen's cell phones in January of 2024 or something, and then we had a search warrant that is being pursued now. And there's a lot of background as to why it's done this way. You don't have to do it this way, but that's where we're at procedurally in this case. Hi, very good to see you, Shaka's Disbelief, and as I mentioned, Dark Side of the Moon and Troy. But yes, this is Karen. In essence, the seizure of the warrant of the phones has already happened. Okay, and this is in the context of whether there's an ongoing investigation of Aidan Kearney and Karen Read under 268.13b and 274.7, witness intimidation and conspiracy, respectively. All right, and the question really before the court is, should Karen be able to argue that these phones, although seized, should not be able to be searched? All right, that is the argument. All right, that's what we're going to read about, and that's the first motion. Yes, indeed, great discussion yesterday, Troy. All right, so here we go. Miss Reads, notice she's no longer the defendant. She must be so pleased that she doesn't have to write the defendant anymore. She gets to write Miss Read. I am a reporter towel. All right, here we go. Miss Read's memorandum in opposition to Commonwealth's motion for examination of digital material seized from Karen Read pursuant to search warrant issued on January 22nd, 2024. All right, here we go. Now comes Karen Read, Miss Read, a third party to this matter because it's technically, it's an ex parte proceeding with the search warrant. Karen's the target of it, but she's not a party to the search warrant application. And respectfully request that this honorable court deny the Commonwealth's motion for examination of digital material seized from Karen Read pursuant to search warrant issued on January 22nd, 2024. The Commonwealth has no probable cause whatsoever to believe there is any new evidence of criminal activity contained within Miss Read's cell phone because any information that the Commonwealth might hope to glean from the requested records is duplicative of the information already contained in Mr. Kearney's cellular telephone records, which have been in the Commonwealth's possession since the start of this case. So, whoa! I knew it. I knew it. She wants them to target Kearney. Do you see what she's saying? She's like, whatever you want from me, you already have on Kearney's phone. And she's talking about this case, so Kearney and her are the targets. That's wild. I got this read right away. The Commonwealth has failed to allege particularized facts that any information contained in Miss Read's cellular records, beyond information that is already in the Commonwealth's possession, is relevant in any way. This court should return Miss Read's personal property immediately. Factual background. Ms. Read's phone was searched by the Massachusetts State Police pursuant to a search warrant issued on February 2nd, 2022. 4 months later, on June 9th, 2022, Ms. Read was arrested for a second time for the same incident. On January 24th, 2024, Lieutenant John Fanning seized 2 more of Ms. Read's cell phones pursuant to a seizure warrant issued on the basis of, quote, witness intimidation allegedly perpetrated by Ms. Read. Now, that was Tully's affidavit. So Fanning served the warrant, but Tully wrote it. Fanning and Tully were partners for like 20 years. They're both involved in the Birchmore case, too. And look at, there's evidence that John Fanning, the guy who wrote the Birchmore cover-up report, in my opinion, was involved with Tully having Fanning serve information or seize the phones from Read. On March 27, 2024, unbeknownst to Miss Read, the Commonwealth convened a grand jury to determine whether a true bill should issue requiring Miss Read to stand trial for numerous counts of conspiring with Mr. Kearney to engage in witness intimidation and or harassment against Brian Albert, Colin Albert, Chris Albert, Jennifer McCabe, Matthew McCabe, and former trooper Michael Proctor. On the very same day, March 27, 2024, the grand jury concluded that there was insufficient evidence to find probable cause that Miss Read committed the acts of intimidating or harassing the witnesses, officially rejecting the Commonwealth's allegation. On July 1st, 2024, a mistrial was declared after the jury deadlocked. Hello, Anthony Barton. Hello, Towel friends. So good to see so many of you joining in. Reading through a new filing from Karen Read, if you're just joining in, related to the search of her phones that were seized in January of 2024. officially rejecting the Commonwealth's allegations. On July 1st, 2024, a mistrial was declared after the jury deadlocked. Ms. Reed did not learn about the grand jury's rejection of her alleged involvement in witness intimidation until a notice of discovery produced by the Commonwealth on October 10th, 2024, approximately 6 months later. On April 22, 2025, 1 year after the start of her first murder trial, Ms. Reed was retried for second-degree murder, manslaughter, and leaving the scene. I thought there was DUI in there. That might... Was it? Wasn't it also DUI? Oh, no, that was a lesser included offense. On June 18, 2025, the 3.5-year saga came to a just end when the jury acquitted Ms. Reed of all charges related to John O'Keefe's death. After her acquittal, the Commonwealth remained in possession of Ms. Reed's personal property. Well, they were two different investigations. On July 28, 2025, Ms. Reed filed 2 motions for the return of her property. One for her Lexus SUV and cell phone seized on January 29, 2022, and a second for the 2 cell phones seized on January 24, 2024. Ms. Reed's motion to return her vehicle and cell phone that was seized on January 29, 2022 was granted without objection. So that's that cell phone, the first one, and then the vehicles. Now we have the separate issue of these 2 phones. That was granted without objection on August 11, 2025. Rather than complying with Ms. Reed's motion to return her 2 cell phones that were seized on January 24, 2024, however, the Commonwealth submitted the instant motion for examination of Ms. Reed's latter 2 cell phones. Right. I think we read that one from Robert Cosgrove. Hi, Julia. Hi, Risa. It is so good to see you. God bless you all for being with us today. Now, let's take a look at the argument. Legal landscape and evidentiary standard. In Massachusetts, like many other states, prosecutors may, in certain circumstances, present identical evidence to a second grand jury after failing to obtain an indictment from a first grand jury. See Commonwealth v. McCrae, 430 Mass, 758, so that's the pin site, or that's the start of it. 763 is the pin site, 2000. However, this power is not absolute. The purpose of indictment by a grand jury is to shield the innocent against hasty, malicious, and oppressive public prosecutions. Internal quotations omitted. Repeated submissions of identical evidence to successive grand juries, especially in light of harassing, malicious, and biased prosecution, poses a limitation on the prosecution's ability to resubmit evidence to a new grand jury. I saw someone quote this earlier as like a negative for Karen. No, bro, that is a positive argument for Karen. Framing the Commonwealth's attempt to convene and submit this evidence that she's arguing is duplicative as harassing Karen, basically. And it's basically saying that although there's the power to resubmit substantially similar or identical evidence to a new grand jury because of prosecutorial discretion, Karen's lawyer is saying it's that the prosecution is kind of like badgering her, and so their limited power to resubmit the same evidence is basically impeded here by their Karen's lawyer is alleging the state's harassing, malicious, and biased prosecution. So someone quoted, and the only reason I'm addressing that is someone quoted on Twitter or X earlier saying it was a negative for Karen. No, that's a positive argument for Karen. That does not make Karen look, that makes the state look bad. The first part up at the top there, where it says, in Massachusetts, like many other states, prosecutors may, in certain circumstances, present identical evidence to a second grand jury after failing to obtain an indictment from a first grand jury. That's the part that harms Karen. And then her lawyer argues an exception to that. It's a strong argument from her lawyer. By the way, I'm not a lawyer. This is not legal advice. We're reading a document. All right, here we go. Repeated submissions of identical evidence to successive grand juries, especially in light of harassing, malicious, and biased prosecution, poses a limitation on the prosecution's ability to resubmit evidence to a new grand jury. For example, when a governmental body has no legitimate or reasonable purpose for pursuing an indictment by grand jury after repeated attempts, the court may inquire into the prosecution's stated purpose and prevent resubmission. See In re U.S. of the United States of America. This is a third F3D. It's a First Circuit decision. 441 F3D starts page 44, pin site 63, First Circuit 2006, which is controlling. because we're in the First Circuit. See also State v. Shaw, 455 New Jersey, Super 471, must be Supreme Court, 471 New Jersey, AD 2018. So the first one is controlling, the second one is persuasive. It's a state case from New Jersey. And then I think this is a quote from the New Jersey case. Quote, some courts have indicated that even in the absence of statutory limitations, the power to resubmit is not boundless nor immune from judicial control. Okay, but is that what the Second Circuit said in United States of America, 441 F3D 4463? Let's take a look. Let's see if Karen's lawyer lives up to his reputation, shall we? He's probably like, oh no, what are you doing, Towel? I'm doing it. Let's take a look. All right. Okay, I found the case. Is this it? This isn't right, is it? Hold on one second. It's in United States of America. All right. So what are we looking for here? We're looking for a citation to stated purpose. So let's look for the word indictment. I mean, I guess this seems to be the case, but I have it as USV, but that just must be the wrong link. I think this is it. Yeah, okay, this is it. This is extremely frustrating. Is their brief? I don't want the petition, I want the decision. This case is actually really hard to find. Oh, let me see here. I think I found it. One second. I think he got it from the Congressional Research Service. One second. It's important to me because I want to see if this case, which is the only controlling one he cites, is actually right, if it stands for this proposition. Alright. Let's see. Citation 97. No, that doesn't seem right. Why is this case so hard to find? I'm utterly baffled. I would like to know what this case is about. I mean, we can move on if we have to, but I really would like to see what this case is about. And I mean, you'll have to forgive me because it's just my kind of compulsion, but it's harder than you think to find this case. Somebody else cites it for the proposition that the principle that a judge's ruling and statements in the course of proceedings before him or her rarely provide a basis for recusal. Okay, but that's not what I want. Why can't I find this specific case? This is bothering me. There's a lot of people that cite to it, but I can't find the actual decision. We can move on. It's not like the most important thing in the entire world, but it's definitely not a case you can just pull out anywhere. I find it cited a lot, but I don't see it actually. I can't find the actual ruling. Must be on Lexis or something. I don't want to look for it right now. All right. Anyway, continuing. See also, but it is kind of an important point because I'd like to know if State v. Shaw, the New Jersey case, stands for the same proposition as In re U.S. of America from 441 F3D 4463. So, I mean, I'm very interested in that, but I don't have time to really dive into it. In Commonwealth v. McCravey, if anyone has a link, though, to this case, not the petition, I'm looking for the actual decision here. It's in re United States of America, 441 F3D 4463 from the First Circuit in 2006. I would just really like to know if it's identical. I don't think it's in opposite to State v. Shaw, but I just really would like to know if it stands for the same proposition, because he doesn't, the lawyer for Karen doesn't take the quote from the case that's controlling. That's what kind of caught my eye. He takes a quote from the New Jersey case, which is persuasive. So what is it that happened in INRI US v. America that stands for this proposition that the court can inquire into the prosecution's stated purpose and prevent resubmission? I don't know, but it's very, very interesting the way it's constructed. I need to find the case. I'll do it another time. In Commonwealth v. McCravey, it looks like McCravey, the Massachusetts Supreme Judicial Court stated it would bear consideration whether submission of the same evidence to multiple grand juries would be inconsistent with the purpose of grand juries to, quote, shield the innocent against hasty, malicious, and oppressive public prosecutions. Now this comes from 430 Mass 758 723 NE 2D 517 2022 517 522 2000, which is quoting Jones v. Robbins from 1857. All right, this one I should be able to find. So give me a second. Let's see if I can find this. I want to see if this is what they actually said. All right, here we go. So I got it on Lexis. It was just a Google result, but he's quoting it to say what? That it bears consideration whether submission of the same evidence. Okay, so let's look for consideration. All right, here we go. I'm going to bring up this case for you, all right? It's Commonwealth v. McCravey or something. All right, so, all right, let's figure out what the hell this case is about. I'll show you how to, figure out what's going on with something like this. So let me make sure you can see it first, all right? So what you do is you go find the case, all right? Because this is why you cite it that way, so the judge can go find it. You don't want to bother the judge. The judge should be able to find it right away. And so this is the case they're citing, Karen's lawyer. Let me just make sure, right? Yep. And they're citing in particular, 758, 723. I think you mean 723, 758, but okay. And they're citing it in particular for the proposition that it bears consideration whether submission of the same evidence to multiple grand juries would be inconsistent with the purpose of grand juries. Let's see if that's what this actually stands for. And so this is from 2000. Here we go. This matter is before us on the defendant's appeal from his conviction of driving negligently or recklessly so as to endanger the safety of the public. We transferred the case to this court sua sponte on our own motion. The defendant claims error in three respects. First, he contends that the Commonwealth impermissibly presented to the grand jury the same evidence that had already been found insufficient by a prior grand jury. Oh, so it does bear directly on this. Second, he challenges certain remarks of the prosecutor during his closing argument. Finally, he argues that the sentence imposed by the trial judge was unlawful because it took into account the death of the passenger in the car the defendant was driving, a homicide for which the jury had not found the defendant responsible. We affirm the conviction, but remand the case to the Superior Court for resentencing. Okay, so we only want the first prong, all right? We want to look at the court's analysis of whether the Commonwealth impermissibly presented to the grand jury the same evidence that had already been found insufficient by a prior grand jury. Okay, so let's take a look. All right, what happened here? On the night of July 30th, 95, defendant spent several hours at a nightclub in Quincy. After it closed, the defendant and Daniel Archibald left together in a Corvette. The defendant was driving while on West Squantum Street, a windy road through Quincy and Milton. The defendant's automobile flipped over. There's contested view of the events. The defendant contended that the accident had been caused when he was cut off by another driver, speeding by him in a Porsche. Commonwealth contends the driver of the Porsche was traveling ahead of the defendant's Corvette. The defendant had been traveling above the speed limit, was intoxicated, lost control of the car as he entered the curve. The defendant removed himself from the car. Archibald was trapped in the wreckage. They freed Archibald. The defendant helped free the passenger who was unconscious and injured. He was transported, the passenger, where he died. Oh, to the hospital. A BAC was taken, and it revealed that the defendant had a BAC of .12. It was right above the legal limit, and it permits an inference that you're under the influence. They then arrested him. The Commonwealth, on September, here's where we want to pay attention. On September 13th and September 27th, 1995, the Commonwealth presented evidence to a grand jury in Norfolk County concerning the motor vehicle accident and Archibald's death. The Grand jury returned only one indictment, charging the defendant with operating motor vehicle while under the influence of intoxicating liquor. The Commonwealth did not proceed on that indictment. Rather, on October 4th, 1995, the Commonwealth presented its case to a second grand jury in Norfolk County that returned 6 indictments against the defendant. What the fuck? So, are you telling me they can go to a grand jury, get an indictment, be like, oh, well, I don't really, that's not even no true billing. They can just get an indictment they don't really like, and they can still go back and try again. Whoa. The Commonwealth did not proceed on that indictment. Rather, on October 4th, 1995, the Commonwealth presented its case to a second grand jury in Norfolk County that returned 6 indictments against the defendant. Homicide by motor vehicle while OUI, homicide by motor vehicle while OUI, homicide by motor vehicle operating recklessly or negligently or recklessly operating a motor vehicle so as to endanger the safety of the public, speeding in violation of MGL. In October of 97, the defendant was tried. It took 2 years. Yeah. In October of 97, the defendant was tried before a jury in the Superior Court. The defendant was convicted of 2 misdemeanors: negligently or recklessly operating a motor vehicle so as to endanger the safety of the public, and speeding. So wow, this county, they don't do well when they try to charge this crime. Motor vehicle homicide, OUI. They swung and missed on this one too. He was acquitted on all the other charges. The judge sentenced the defendant to 1 year in a house of correction, 6 months to be served, and the balance suspended for 2 years. Before trial, the defendant filed a motion to dismiss all indictments on the grounds that the resubmission... Oh, here we go. This is operative. You see how fun this is? Before trial, the defendant... This is called shepherdizing. Before trial, the defendant filed a motion to dismiss all indictments on the grounds that the resubmission of the same evidence to a second grand jury impaired the integrity of the grand jury process. The motion was denied. The defendant argues that order to the denial violated his right to due process and fair presentment as guaranteed under Article 12 of the Massachusetts Declaration of Rights. See Commonwealth v. Moran. Article 12 pertains to basic rights of an accused, including our equivalent of the 14th Amendment's Due Process Clause. The right of an individual citizen to be secure from the public accusation of crime and from the trouble, expense, and anxiety of a public trial before a probable cause is established by the presentment and indictment of a grand jury. Jones v. Robbins from 1857 is not specifically mentioned in Article 12.4 CF 5th Amendment to the United States Constitution. So they're saying you have an indictment requirement in the U.S. Constitution, federal Constitution, but you don't have that requirement. You have a right to be indicted in the federal context. You don't necessarily have it in the state context. It's not specifically enumerated in the Massachusetts Declaration or Constitution, Article 12.4, which we're going to find out is very important. Nevertheless, presentment and indictment by a grand jury is one of, quote, the greatest securities of private right handed down, so it's a common law right, handed down to us among the liberties and privileges which our ancestors enjoyed at the time of their emigration and claim to hold and retain as their birthright. Okay. Jones v. Robbins, Commonwealth v. Mayfield. Right to grand jury indictment as to serious crime is constitutionally based in Article 12. So it's an unenumerated right in the Massachusetts Constitution, but only for serious crimes. Latal v. District Court of East Hampton, same, Commonwealth v. Hawley, Gray. The great principle asserted by the Declaration of Rights is that, and we should cite the Magna Carta too, is that no man shall be put to answer a criminal charge until the criminating evidence has been laid down before a grand jury and they have found probable cause, at least, to believe the facts true on which the criminality depends. As, quote, one of the ancient immunities and privileges of English liberty, the right to indictment by a grand jury carried no attendant limitation on a prosecutor precluding resubmission of the same evidence to successive grand juries. Okay, let's unpack that. The right to indictment by grand jury carried no limitation on a prosecutor precluding, so preventing the prosecutor from resubmitting the same evidence to another grand jury. Rather, at common law, a prosecutor retained the discretion to resubmit a charge to a grand jury after having been dismissed by a previous grand jury. See U.S. v. Martin. from the 1892. The, quote, doctrine in the United States is that the ignoring of an indictment by one grand jury is no bar to a subsequent grand jury investigating the charge and finding an indictment for the same offense. While Article 12 preserved the right of the accused to... So this is not looking good for Karen. While Article 12 preserved the right of the accused to indictment by a grand jury, we have now had occasion to recognize a correlative right to limit to one grand jury and one only submission of the same evidence. We decline to do so now. While Article 12 preserved the right of the accused to indictment by a grand jury, we have not had occasion to recognize a correlative right to limit to one grand jury and only one submission of the same evidence. We decline to do so now. Under federal law, it is settled that the same matters may be considered by more than one grand jury. A minority of states restrict the resubmission of criminal charges to a second grand jury, but in each instance, the restriction is a result of legislative enactment rather than by judicial decision. Most of those statutes require that the government first obtain leave of court before a criminal charge may be resubmitted. The Massachusetts legislature has not imposed any such requirement on Massachusetts prosecutors. Moreover, we are not aware of any judicial decision limiting the discretion of the government to resubmit a case to a second grand jury in the absence of a statute. Compare State v. Rizzo, declining to decide whether court may bar resubmission. Our decision in Commonwealth v. Westerman is not to the contrary, for in that case we consider only whether a second grand jury could consider matters currently under consideration by a prior grand jury whose term had been extended. We are asked to consider here whether a prosecutor may present the same evidence to a second grand jury. We do not consider whether repeated submissions of the same evidence to this multiple grand juries would withstand scrutiny. The Commonwealth suggests that there is no such outer limit because, unlike the protections afforded to defendant by the privilege against double jeopardy, forcing the individual to appear before multiple grand juries would not be unduly harassing, but the purpose of indictment... All right, so hold on. I got to find the rest of the decision. This is actually very, very on point, so I want to read the rest of it, and they make you register, so give me 1 second. I'll be able to find the full decision. Alright, I found it. 1 second. This is actually very, very good. I'm glad we're reading this together. This is very important. It's literally directly on point, and we need to see what the court says, because that's going to tell us. Remember, Karen's only making an argument. The judge will decide this based on the precedent. So, let's go. We're going to pick up where we left off. Hold on. We probably picked up right here. Alright. We are asked to consider here only whether a prosecutor may present the same evidence to a second grand jury. We do not consider whether repeated submissions of the same evidence to multiple grand juries would withstand scrutiny. The Commonwealth suggests that there is no such outer limit because, unlike the protections afforded a defendant by the privilege against double jeopardy, forcing an individual to appear before multiple grand juries would not be unduly harassing. But the purpose of indictment by a grand jury is to shield the innocent against hasty, malicious, and oppressive public prosecutions, citing Jones v. Robbins. Whether submission of the same evidence to multiple grand juries would be inconsistent with that purpose would bear consideration. Resubmission of the same evidence to 2 grand juries presents no such difficulty. Karen's lawyer. You gotta continue the sentence. This is only their second grand jury. There was only one before, on March 27th of 2024. It's in opposite. It's in opposite, and the judge is going to know it's in opposite. All you have to do is go read Commonwealth v. McRae. It's in opposite. It does not stand... It stands for the proposition that if we got to like 3 or 4 or 5 grand juries, you have an argument. But literally, read the last sentence that you didn't include, if I recall, Karen's lawyer. It would bear consideration whether submission of the same evidence to multiple grand juries would be inconsistent with the purpose of grand juries. But what does it actually say? That's true. Whether submission of the same evidence to multiple grand juries would be inconsistent with that purpose would bear consideration. Resubmission of the same evidence to 2 grand juries presents no such difficulty. Can't pull a fast one on me. I'm a little towel. I'm a little towel. Karen, you're going to lose this motion, sorry. Your lawyer, I'm not a lawyer, this is not legal advice, but that lawyer tried to pull a fast one, and he's not going to win. Because it's the second grand jury. Okay, we read the facts, we read the issue. Brah. You're going to insult the judge with that argument. All right? Look at that. It's black letter law. It's right there, man. It's right there, bro. Resubmission of the same evidence to two grand juries presents no such difficulty. They're juxtaposing it. The word multiple here literally means more than two. Literally, because it's juxtaposed with, in this case, at bar that we're reading, McCravey, it was two. It was two grand juries. Now, the only potential bar here would be if the previous grand jury had its term extended and then they tried to present it to another grand jury while the first one was active with its term extended. We don't have that. And the court, the SJC, says, listen, it's a legislative issue. Some states, a minority of them, bar resubmission without judicial permission. Massachusetts didn't adopt that standard. The federal rule doesn't require it. This case law doesn't require. All this court is saying, the SJC, under this decision, that Karen relies on in a way that's not going to help her, is that you can't have more than two. And it's not even saying that. It's saying the court, the SJC, are saying we haven't really had an opportunity to come up against a case where there's like three grand juries for the same thing, right? But even in this case, okay, which is McCravey or something, that fact pattern is way more deferential to the defendant than Karen's fact pattern, in my opinion, because the state, Norfolk County prosecutors, must have been under William Delahunt if it was 95. They went to the grand jury the first time. They got one indictment for like OUI. They didn't want to do that. They went back. They got 6 indictments, bro. 6 indictments on the second grand jury, and the defendant's challenging the fact that the Norfolk County was like, prosecutors were like, yeah, we don't like that the first grand jury gave us 1. Let's go back, and we got 6. The court's saying that's okay. Now the dude got off. He only got convicted on 2 of the 6 counts. So then there's a question about closing arguments. I just want to find out why the court remanded for sentencing. And then apparently the prosecutor went way overboard in their closing arguments. The fact that the passenger died was taken into consideration. Let's see. It appears to us from these statements that the judge may have sentenced the defendant more harshly than he otherwise would have because he believed the defendant's actions caused the death of Daniel Archibald. In order to clarify whether the judge sentenced the defendant more severely because he held him responsible for Archibald's death, which the judge can't do, we remand the case to Superior Court for resentencing solely on the charge of which the defendant was convicted. Wow, and he was only going to have to serve 6 months. They wouldn't even let the judge impose that because they said it was too harsh, and the judge was trying to punish him for something he wasn't convicted for. So those are 2 issues, though. This guy lost on trying to dismiss everything, and the operative paragraph is right here. And I'm a little bit, I don't know, maybe it's just because I took the time to actually shepherdize it, but I'm a little disappointed that Karen's lawyer made this argument because, like, this guarantees Karen's going to lose this motion, this case right here. It's controlling. It's on point. It's from the SJC. It literally enumerates why the legislature allows this to happen by omission, even though they could adopt the minority rule if they wanted to, but they haven't. And this is only the second grand jury Karen's facing for this specific thing. Yeah, I don't know why I get why he tried to cite it, because what he's arguing, and I get what he's doing here. He's setting it up so that if she gets no true build again, okay, then this, you see what I'm saying? Then this argument is really strong. I got some towel french fries. If she gets no true build again, then this argument is really strong. I think most DAs probably know this case, that if you no true build somebody twice, you're pushing it if you go back for a third one, because you could get an SJC ruling basically by common law imposing a limit, or at least imposing a requirement that you need to motion for judicial permission after like when you go for the third grand jury. But we're only on 2 for Karen. If that's the crux of her whole argument, she's not going to win this motion because of this case that her lawyer cited. Yeah, it's not good. Again, her lawyer cites this. And yeah, there might be a time and a place for this, but if that's all he got, not going to win this motion. Sorry. All right. Well, quote, it is the general... All right, so let's pause for a sec. That's what he's got to overcome. All right, we just read the case. Let's see how he tries to overcome that. I'll listen to his argument. I'll give it the time of day. But I'm telling you, that's a very high bar to get over. So how are you going to convince me that even though there's explicit language saying 2 grand juries is fine, specific language from the court, and the rationale is strong and it holds because of legislative inaction, what exactly are you going to argue to me to justify why you think that for some reason there's a preclusion on a second grand jury? I'll listen to the argument, but I don't really understand how he's going to argue this. Well, quote, it is the general rule that a court should not inquire into the adequacy or competency of the evidence upon which an indictment is based. When it appears that the integrity of the grand jury process has been impaired, a defendant may attack the validity of the indictment by way of a motion to dismiss. Bro, okay, sure, Odell, DiBenedetto, McCarthy, you haven't been indicted. So what are you All right, where are you taking me here? We're on a bit of a lazy river. Where are you taking me with this argument, Karen's lawyer? What are you saying? She hasn't been indicted. So what is your argument? Although no indictment has been... There better be a really, really strong case on this. Although no indictment has been secured in this case, the process of seeking same bears on the analysis similarly. All right. See, I told you I'd give him the time of day. Improperly seeking evidence under the guise of later seeking an indictment impairs the process from the outset, which the courts are loath to sanction. Okay? Can I have a legal argument for this, please? No, I'm not in limbo. None yet. I'm just baffled by the construction of the argument, because that statement is true. The argument here, like about Odell, DiBenedetto, McCarthy motions to dismiss. But this is the part I don't understand. Arguing like before she's been indicted that it impairs the process. But I'm reading it. That's why we're going through it. The pertinent witness intimidation statute reads as follows. MGL 268.13b. Whoever willfully, either directly or indirectly, threatens, attempts, or causes physical, emotional, or economic injury or property damage to, conveys a gift, offer, or promise of anything of value to, or misleads, intimidates, or harasses another person who is a witness or potential witness, person who is or was aware of information, records, documents, or objects that relate to a violation of a criminal law or violation of conditions of probation, parole, bail, or other court order. Judge, juror, grand juror, attorney, victim, witness, advocate, police officer, corrections officer, federal agent, investigator, clerk, court officer, court reporter, court interpreter, probation officer, or parole officer, person who is or was attending, or a person who had made known an intention to attend a proceeding described in this section, or family member of a person described in this section with the intent to or with reckless disregard for the fact that it may impede, obstruct, delay, prevent, or otherwise interfere with a criminal investigation at any stage, grand jury proceeding, a dangerousness hearing, a motion hearing, a trial, or other criminal proceeding of any type, or a parole hearing, parole violation proceeding, or probation violation proceeding, or an administrative hearing, or a probate or family court proceeding, juvenile proceeding, housing proceeding, land proceeding, clerk's hearing, court-ordered mediation, or any other civil proceeding of any type, or punish, harm, or otherwise retaliate against any such person described in this section for such person or such person's family members' participation in any of the proceedings described in this section shall be punished. Article 14 of the Massachusetts Constitution requires that all searches and seizures be reasonable. Commonwealth v. Alex. Searches and seizures conducted outside the scope of a valid warrant are presumed to be unreasonable and therefore unconstitutional. To be reasonable in the constitutional sense, a search conducted pursuant to a warrant must be supported by probable cause. To comport with constitutional protections, an affidavit in support of a search warrant must demonstrate probable cause to believe, 1, that a particularly described offense has been, is being, or is about to be committed, 2, that the search will produce evidence of such offense or will aid in the apprehension of a person who the applicant has probable cause to believe has committed, is committing, or is about to commit such an offense. In addition, a cell phone search must be timely. The state must act within a reasonable period after seizure. This is a good argument. Else the seized material must be excluded. That's a strong argument. That's a very firm principle. The Commonwealth, number 2, the Commonwealth has no legitimate purpose for its motion and is simply attempting to continue its persecution of Karen Read. Punny. The Commonwealth lacks the necessary probable cause to support their requested search warrant because the requested search will not produce evidence of the alleged offense, nor will it aid in the apprehension of an alleged perpetrator. The basis of the Commonwealth's inquiry into Miss Read for the offense of witness intimidation is a groundless allegation of indirect witness intimidation. This is evidenced by Trooper Tully's supporting affidavit, which only describes conclusory allegations of witness intimidation as occurring through Miss Read's communications with Mr. Kiani. It is murky whether he believes Tully those communications were direct or indirect, and he has no stated foundation. It's because they didn't have Lindsay testify. And he has no stated foundation that any communications actually are in furtherance of witness intimidation. Rather, Tully spends nearly the entire affidavit describing Kearney's alleged conduct, not Miss Read's. I told you she's throwing Aiden under the bus. The communications presented by Trooper Tully between Mr. Kearney and Miss Read actually show the opposite of witness intimidation. Karen is clear that information should not be used or disclosed or disseminated. There is absolutely no evidence of Miss Read ever urging or even suggesting to Mr. Kearney that any witness be contacted, approached, or even discussed in Mr. Kearney's reporting. Yeah, so here's the problem. In March of 2024, that was true. In May of 2024, they got more information from the group chat, the Facebook group chat, where Aiden said some things that implied Karen did tell him to run Jen McCabe's plates and approach her at a game. That was Aiden's old... No wonder Karen doesn't like Aiden. Further, the Commonwealth lacks probable cause to search Miss Read's cell phone in accordance with either of the standards in the second prong of the Easterbrook test, because they are already in possession of all information pertinent to the prospective allegations. This is a strong argument if they're right. If they're right that everything Karen said to Aiden is on Aiden's devices, it's a very strong argument. Very strong. This was apparently written by her civil lawyer, from what I saw at the end of the document. We can double check. Yeah. No. Is that a different guy? It just might be that the civil attorney has a similar name to Stephen Buzang. 1 second. Let me get that other guy's name. Damon Seligson. Yeah, so it's not Seligson. For some reason, I thought Seligson was Buzang. I don't know who Stephen Buzang is. I guess he's our only lawyer on this search warrant case. Probably someone Yannetti knows. Anyway, let's keep reading. So, I was wrong. There's a civil attorney who's like New Zealandish or British who is named Damon Seligson. That is not who wrote this. This was written by a lawyer named Stephen C. Buzang, who I guess is on the search warrant case for Karen. But yeah, very different than how Alan writes motions. It's very, it's not bombastic. It's very legal, very IRAC. It's kind of refreshing. Not that I don't like Alan's style, but this is what I'm used to, these documents. This is a very conventional legal argument. It's strong in places, weak in others. Best he could have done. All right. Yep, Buzang, Meredith, exactly. And it does appear that Buzang took over after David Unetti and Alan dropped off the criminal cases. All right, let's continue. So this is where I think the argument could get strong. Now I'm starting to see why she doesn't care about Aiden anymore. Her best argument is that it was all Aiden. Everything you need's on Aiden's phone. Charge Aiden. That's her argument, basically. All right, here we go. Further, the Commonwealth lacks probable cause to search Miss Reed's cell phone in accordance with either of the standards in the second prong of the Easterbrook test because they are already in possession of all information pertinent to the prospective allegations. Paragraph 7 through 41, which I think is mostly about Natalie, of Trooper Tully's affidavit, have nothing whatsoever to do with Miss Reed and only concern Mr. Kearney. That's true. It's like about the rolling rally and all that shit. Paragraph 44 of Trooper Tully's affidavit perfectly encapsulates the reason why the search warrant is unnecessary and why the Commonwealth lacks probable cause to search Miss Reed's phones. Paragraph 44 reads, remember, we listened to this interview with Natalie yesterday. That was the basis of Tully's affidavit. Paragraph 44 reads, Natalie describes the arrangement as follows. Karen would send Natalie a message on Signal intended for Kearney. Natalie would copy and paste the message, photo, video document into a text message to Kearney. On several occasions, Natalie would take a screenshot of the Signal messages from Karen and send Kearney the screenshot. Natalie stated she would send information to 2 phone numbers used by Kearney. Because the Commonwealth, now going back to Karen's lawyer, because the Commonwealth's groundless allegation seeks to suggest that Miss Reed communicated some unknown things to Mr. Kearney, and he thereafter engaged in witness intimidation, the only relevant communications would be those actually received by Mr. Kearney. For example, if a hypothetical communication was written by Miss Reed on her phone but not passed along to Mr. Kearney, that cannot possibly be an example of witness intimidation, as the Commonwealth has not and does not allege that Miss Reed actually carried out any intimidation herself. Therefore, as all relevant communications would be those received by Mr. Kearney and the Commonwealth, is already in possession of all communications received by Mr. Kearney. The Commonwealth has searched the entirety of his phone. That's a bit of a misnomer. Aiden has 6 phones that were seized and searched. 2 of them have already been searched. 4 of them are subject to a taint team review. So it's not 1 phone. It's 6 phones. And only 2 have been searched. So that's just wrong. But it still goes to the point, though. They have Kearney's devices. It is impossible that a search of Miss Reed's phones would produce any evidence, communication, that is not already in the Commonwealth's possession. The same reasoning applies to the following paragraphs of Trooper Tully's affidavit as the Commonwealth is already in possession of Mr. Kearney's cell phone messages. That's the Lindsay paragraphs. All right. Okay. The Commonwealth has the other side of the handshake, if such exists, which is a good pun because they were using encrypted apps, and when they exchange 256 AES bit encrypted keys and they decrypt them, it's called a handshake. Smart lawyer. Therefore, the Commonwealth lacks probable cause to search Miss Reed's phones, and the Commonwealth's motion should be denied. The final paragraphs of Trooper Tully's affidavit expose what this motion and the Commonwealth's overall plan truly is. An overbroad and persecutory fishing expedition intended to punish and harass Miss Reed. In paragraphs 96, 97, and 100, Trooper Tully states as a reason for searching Miss Reed's cell phones that the MSP needs to examine Miss Reed's location data and application usage, which is literally everything on the phone, to determine whether the phones actually belong to her. That thinly veiled excuse to rifle through the entirety of 2 of Miss Reed's cell phones, including all her personal information, is absurd. Trooper Tully argued, expecting this court to take him seriously, burn, that the police and district attorney need to review the entire contents of Miss Reed's phones, including whatever personal, private, confidential information lies within, to prove that the cell phones seized from Miss Reed's possession in Miss Reed's own home are in fact hers. The same cell phones that Miss Reed's counsel have demanded be returned to her as the rightful possessor. That's really funny and a good argument. Do you see what he's saying? He's like, you know they're hers. We're telling you, so you can't say the justification for searching all of it is to prove it's hers when we're telling you they're hers. That the Commonwealth would actually present such an argument as justification to root through her personal data speaks volumes about the true intentions of the prosecutor and investigator behind its motion. That's the strongest argument so far. If that's really what Tully argued, you're going to lose that. They're going to get a narrow search warrant. They're not going to get that. That's absurd. I can't believe they argued that. Tully argued that. You have to search the whole thing because you don't know if it's her phone. Alright, now we're going to read the timeliness part. And this is going to be the strongest. I see his style. He gets rid of the weak arguments first. Because really, honestly, the weakest argument in this document was this one. This one. This is his weakest argument. He's going to lose on this. They have a right to do another grand jury. Now, it gets stronger and stronger. This is a good argument. The much stronger argument is what's at the end of section 2. The redundancy argument. Karen really wants them to prosecute Aiden. That's what I get from this so far. And now, I think we're going to get the strongest argument. Karen wants to take away all the state's evidence against her and leave them only with evidence against Aiden. I don't think she wants to cooperate, per se. I don't think she trusts the state. But I think she just wants to deprive them of evidence that's damaging to her. But she's willing to passively give them evidence that hurts Aiden. That's my read of all this. She won't participate in it, but she's only concerned with protecting stuff that's damaging to her. She's going to end up with immunity. They really have. I know it sucks, but if you want to get Aiden Kearney, you really got to give her immunity. People are going to hate that. But that's why the Norfolk DA can't make the decision. Neither can Tully's unit. You got to get someone completely independent from all this stuff. You got to have the judge appoint someone to all these cases. That's the only option. They might do it too. It's a viper's den. It's worse than the CCC. But really, you may actually have to have an independent decision maker here, because I don't think the Norfolk DA, I think they're so conflicted with Tully and Jen McCabe and the O'Keefe family and whatever. It's so conflicted. There's no way Michael Morrissey can make an independent prosecutorial decision about this. I don't think the Norfolk County Superior Court judges, they're going to have to decide what to do here. I'm sure they're already thinking about it. Judge Doolin, the new judge who's going to sit, not a new judge, but the judge who hasn't sat on Aiden's cases before, maybe one time, but not regularly. She will be sitting in December, and she was going to be on the Walsh case, which is, of course, now delayed because Brian Walsh, who was accused of killing his wife, Anna Walsh, got stabbed in prison. They isolated him in the medical unit, and he couldn't access his discovery. They only let him access one box of 3 boxes, so they had to delay the trial. Then his lawyers were like, by isolating him in the medical unit, they induced psychosis, so he had to be sent to a hospital for evaluation because he was stabbed. Hello, Sunken Grave, you are a super towel. Hello, Metro West Granite. has not shared his chicken tenders. I didn't eat chicken tenders today. I had fries and a grilled chicken sub from my favorite place. Thank you to whoever sent over. I don't want to give away people's names because they don't attach their donations always to their usernames, but whoever sent over a $25 lunch donation today, thank you. That went, one, to get my bank balance above zero. I'm embarrassed, but it is what it is. I'm trying to help out. I had to help Towel Mom and do everything I could, and that's its own story. But I used that to get a grilled chicken wrap. I had a coupon for $3 off, and then I got a side, basically for free, of spicy fries. So that was Towel's lunch. I did not have any chicken nuggets today, though, just a grilled chicken wrap. All right. That's pulling me away from the analysis, though. You see what happens when I read the comments? It's great to see you, though, Metro West Granite. Hello, Just Jim and Nunya and Sunken Grave. When my towel friends show up, I like to say hi. But okay, so you can kind of see what's going on here. The arguments are building. They're getting stronger. This lawyer is a good lawyer. I mean, I would guess Yannetti recommended him. Very strong lawyer. He gets his weakest arguments out of the way, then immediately we go into his strongest arguments, and I think we're about to get the strongest argument here. Now, I'm really starting to see, I think, what's going to happen here. Oh, that's what I was pontificating about. They got to get Morrissey. Morrissey cannot be involved indirectly or directly with the decision-making on this. Neither can the MSP or Kate Peter or any of them. There has to be an actual independent person who I think the judges might have to appoint someone on the Lindsay Gattani cases, on the other cases. Look, if you want to see by corollary what's going on, look at the President Trump case down in Fannie Willis's jurisdiction down in Georgia. Now, in Georgia, when there's a referral for a prosecution like that, it goes to a committee or something. We don't have that in Massachusetts. It's a weird thing that's going to happen. But someone is going to, and I've asked around, I've heard this is possible, a judge in the Superior Court can, on their own motion, on their own discretion, appoint a prosecutor who doesn't answer to any district attorney. Okay, I think that's where we're heading. Why do I say that? Because there are so many intractable conflicts of interest with Kate Peter, with Brian Tully, with Ken Mello, with Robert Cosgrove, with Michael Morrissey, with Jen McCabe. There are just so many intractable conflicts of interest. There is no way that anyone in the state police or anyone in the Norfolk DA or anyone in their orbit or anyone they find to be a special prosecutor can make an objective decision, and someone is going to have to make an objective decision as to who gets immunity and who gets charged. I'm sorry, you cannot charge Aidan Kearney and Karen Read. They're going to point the finger at each other. You have to pick one. And I'm not the person who has all the answers, okay? Personally, you can tell that I'm backing Karen right now, not on the John O'Keefe stuff. It's very clear, okay, but on the Aidan Kearney stuff. I truly believe that if Aidan Kearney, and if you compare Aidan Kearney's influence, in my opinion, on our public sphere with Karen Read has a cult of personality that she was mostly interested in using and insulating herself from, a very dangerous state police unit. Whatever you may think about what happened with John O'Keefe's death, she was scared of that state police unit for good reason, I think. They're a scary group. Aidan Kearney has this cycle, in my opinion, of lots of different people being subject to the machinations of his followers and his cult of personality, and it's unhealthy, okay? It's unhealthy in my opinion, for our democracy. It's unhealthy for our justice system. It's unhealthy for our larger societal bonds, okay? It's a pernicious, insidious, subversive, very selfish, ego-driven, in my opinion, culture that arises from that behavior, Aidan Kearney's behavior. As such, we cannot have people who are conflicted making decisions about how this should play out. If there's going to be an immunity decision about Karen Read, it can't be made by people who are friends with the O'Keefe family and friends with Brian Tully and friends with Jen McCabe. Okay? Is getting Karen Read, quote unquote, an important prosecutorial objective? Sure, but they're completely biased by how close, in my opinion, how close that office is to Jen McCabe and Tully and Kate Peter and the O'Keefes. Do I think that those voices matter? Yes, especially the O'Keefes. Okay, I think the O'Keefe's voices matter. But that's not my point. My point is that you cannot have someone who literally has a conflict of interest making the decision about how Aiden and Karen are going to get prosecuted. You can't. Because it's going to require giving either Karen or Aiden immunity. And if you ask the O'Keefes, or if you, in my opinion, or anyone close to Jen McCabe or Kate Peter, they've wanted to give Aiden immunity all along. They've been willing to let him flip on Karen for all the charges to go away. But is that the right decision for our democracy? Is that the right decision for our justice system? Is that the right decision for the victims? And I say victims plural. I don't know the answer. Okay? I'm willing to admit my personal bias. But I don't think the Norfolk DA's office is. I don't think Brian Tully is. I don't think Kate Peter is. I don't think Ken Mello is. I don't think Robert Cosgrove is. And therefore the judges are going to have to do it, in my opinion. They're going to have to appoint someone independent who has no role in this, doesn't know some PI firm or have some company with Marty Kraft who knows Michael Morrissey. No. We got to, in this godforsaken state that is Massachusetts, find someone independent. And we must have the decision made in that regard. And whatever the decision may be, whatever it may be, we just have to have the confidence that it was impartial and fair. Okay? I shouldn't make the decision. God knows. I have a position. I think Karen should get immunity and Aiden should be charged. Okay? But I am just a commentator. It cannot be that Michael Morrissey's office or someone he picks makes this decision. Just like it can't be Karen who makes the decision, just like it can't be Aiden who makes the decision. It has to be an independent voice. We need that. This situation is crying out for an adult. One independent, outside voice to come in, parse it all, and make the charging decision and the immunity decision. Is it going to be a pleasant decision? No. Is everyone going to go home happy? No. But there are no easy answers here. And people are looking for easy answers. And that's what's screwing this whole thing up. No one is taking accountability for their conflicts of interest. Everyone's trying to get their way, and we're at a stalemate, and it's coming at the expense of justice and the vulnerable, and our system is cracking under the pressure. So let's just step in my opinion. The justice system should do what it's really been called to do all along, which is remove everyone from the decision making, put someone independent in there, and let the chips fall where they may. God bless America. We never would have got to this point if someone had done that from the beginning. And I believe we're getting there, folks. I believe we're close. I don't believe for a second that the courts are going to let these charges just go away because Michael Morrissey and Tully are so conflicted they can't find an independent voice or they don't want to. No. Bullshit. The court's going to see right through that, in my opinion, and appoint someone for every case if that's what it takes. All right? Too much wheeling and dealing. Too much inside baseball. Hi, Freebird. Oh, it's a pleasure to have you with us. God bless you, my friend. I love your username. It is wonderful, and I love the song Freebird. The intro on Twitter today, I actually played the song Freebird. All right, let's keep going. Last section of Karen's motion, then we'll watch a 20-minute video from yesterday. Then we'll read the decision in the civil case. Part 3. The Commonwealth's request is untimely, and therefore the information sought cannot be admitted. As we learned extremely recently in Commonwealth v. Diaz, the Commonwealth may not seize a cell phone and indefinitely deprive its owner of their possessory interest before seeking a search warrant. I'm in Crim Pro right now, and we've been talking about this case. I'm not a lawyer. I'm a towel. The police may retain an item seized without a warrant for, quote, the relatively short period of time needed to obtain a search warrant, but must release the item if a warrant is not obtained within this period. That's very new law. Commonwealth v. White. Well, apparently it was a previous standard too, but it was just reinterpreted. Commonwealth v. White, quoting Commonwealth v. Gentile, 437 Mass. 569, 573. If the police fail to obtain a search warrant within a reasonable time, the seizure, even if it was reasonable at its inception, because it was based upon probable cause, that's what we have here, may become unreasonable as a result of the duration. I knew this was going to be her strongest argument. This guy must have been a lawyer for like 40 years. This is what you see like in law school as an example of a very strongly constructed argument. You end with your strongest point. White quoting Segura v. U.S., which is, what district's it from? 7th Circuit. At least the second one. So it's persuasive, not controlling. When officers fail to seek a search warrant at some point, that might be a SCOTUS case actually, Segura v. U.S. When officers fail to seek a search warrant at some point, the delay becomes unreasonable and is actionable under the Fourth Amendment. That means the exclusionary rule kicks in. The Commonwealth or the evidence, the search warrant won't be granted because it becomes unreasonable. Do you understand that there's a difference between no unreasonable search and seizure? Okay, so this is a question of the reasonableness, which is its own standard under the Fourth Amendment. The reasonableness of it has nothing to do with the probable cause, the reasonableness. And we're talking about the temporal requirement here, the nexus between when the seizure warrant issued and when the Commonwealth moved for a search warrant. Do you see? We're at like a 1 year, almost 2 year difference. What are we at, like 19 months or something? 20 months? It cuts against the Commonwealth. That's an extended temporal. Now, the Commonwealth's going to argue, I think, that the case was going on, the criminal trial. Still, I think like 2 weeks is too long. Because what Reed's arguing, and it's correct, you're depriving Reed of a constitutionally protected possessory interest in the phone. You've taken it from her for 2 years. It's a taking of her property. You've deprived her of it. It's unreasonable. It's an unreasonable taking because of how long you've had it. Which you don't even need to argue probable cause if you win on that. And she can win on this. This is her strongest argument. This is why she's waiting to make a decision on what she's going to do with Aiden. She's going to win this. And then she can do whatever she wants because only Aiden will be charged. She's going to lose on the argument about the redundancy of the grand jury. They can present it to 2 grand juries. 3's pushing it, 4 no, in my read, but that's untested law. 2 is okay, 3 pushing it, 4 definitely probably not. All right? It depends, though, on the latter 2 because it's untested. But 2 is okay. She's going to lose on that argument. She's going to win, I think, on the redundancy argument, that they can get anything they need from Kearney's phone. She's going to win on that. And then she's going to win on the strongest part of her argument, which is part 3. They're going to they're not even going to limit the scope of this, in my opinion. They're going to throw out the search of Karen's phone. Do you understand how strong of a position Karen Reed is going to be in if she wins this? And I think she's going to win it. The first argument was weak. I was like, oh, she's screwed. But no, it got so strong by the end. I hope you all realize, the supporters of Karen Reed, I told you she was a tactical genius. If she wins this specific component of the argument, she's in the strongest position possible. She'll have a hand in the situation. Only Aiden will get charged, and they're going to have to give her immunity. They should give her immunity. That's my opinion. The strongest ally of the Commonwealth of Massachusetts right now, in terms of holding Aiden Kearney accountable, is Karen Reed. Now, not the strongest ally of Michael Morrissey and the Norfolk DA and Kate Peter and Brian Tully and all them. They don't want to do that. But what I think justice demands is immunity for Karen Reed. I'm not talking about John O'Keefe here. We're talking about for this case, the instant case. This, what the judge is talking about, or what Reed's lawyer is talking about. That's the right decision. Sorry. That's the right decision. I've thought about it. I'm not a lawyer. This is not legal advice, but I've thought about it. I'm probably the best positioned person, even more so than some of the people who review the record of this case. I'm probably the best positioned person, knowing all the factions involved, all the people involved, all the personalities, to tell you the right decision, what justice demands, not in the John O'Keefe civil case, not in the John O'Keefe even criminal case, okay, even though that's settled. In this specific matter, as to the witness intimidation, the conspiracy, whatever, she Karen should be given immunity. That's my opinion. And it frustrates me that this became a political question. It shouldn't have been a political question. It should have been a question of justice. Now, Karen's basically forcing them, if she wins this, which I think she will. This is the first, as I mentioned, the first argument isn't very strong, but the second and third argument she makes here, even if the second one doesn't win, the third is a very strong argument. That this is way too long to keep her phones. They lose on this, which they might. I'm telling you, just because you're the DA and you move to do something doesn't mean you're going to win. She wins on this, they may have to. Especially if a new independent prosecutor, unrelated to Morrissey or Tully or Mello or whoever, Marty Kraft, Kate, Peter, somebody independent comes in and Karen's won this motion, if they throw out the search of her phones, she's your witness. She's your star witness. And the price is immunity. And I would give it to her. One, she deserves it, all right? Like, love her or hate her, she went to war with you and she won. Okay? Move on. You know, that's my opinion as an analyst. Let her repent in her own way. You don't think that wears on her soul, bro? I've never spoken to her. But do you think that woman doesn't go to bed every single night tormented by what she did and what happened? Come on. I don't care how brave of a face she puts on in public. And she definitely doesn't ever cry in front of people. But do you really think that, like, she's a Catholic woman, I think. I believe her family's Catholic. Like, you don't go to bed without that weighing on you. Let her repent in her own way. Let Meredith repent in her own way. For the alt accounts, you know. If you want people to actually go through repentance, don't force it on them. Like, show them some grace. And I really do think they deserve it. I'm sorry, I think they deserve it. And you shouldn't underestimate, in my opinion, either Karen Read or Meredith. Or Lindsay, for that matter. But in particular with Karen, I don't think she is this supervillain. I don't. I've looked into her eyes. What I see is a scared person who made bad choices and doesn't understand why some people hate her and won't forgive her. And listen, I can't dish out forgiveness, okay? I just have my personal view on this, which is it's wrong to just torment the woman, Karen, because you have a personal bias and you're in the decision-making chain. There's bigger questions at issue here about Aiden, about Aidan Kearney, about the prosecution, about the tactical approach to it, about what the value of cooperation is. And those it's really... That's what I think people are struggling to understand. You have to parse out your feelings about each of the individual actors involved in this, or players. Karen, Aiden, Tully, Kate, Morrissey. You have to parse all of that out, okay? And you just have to think about it from the perspective of judicial economy, okay? What is the most effective way to pursue charges? The seriousness of the harm. Okay, you have to compare Aidan Kearney and Karen Read. And yes, we do have someone's life who was lost on the night, John O'Keefe's, on the night into early morning of January 28th into January 29th, 2022. You have to weigh all that. And no one is saying you should not take that into consideration. You then have to weigh what the person cooperating has to offer. And then you have to weigh the interests of the public. That is a totality of the circumstances. No one factor weighs more heavy than any other. You must weigh them all, and then you must make an independent decision on behalf of the best interests of this ethereal concept that we call democracy, representative democracy, fleeting though it may be. And you must make that decision in a way that reflects the principles that define the system. And we fell away from that. That's what I'm trying to say. It's that bothers me. That we fell away from that duty to have these universal principles that define our decision-making in the justice system, and that's what brought us to this position. And so what you hear in my voice, the incredulity, is not a result of the fact that I'm just gratuitously praising Karen Read. It is that we created conflicts of interest in this justice system that allowed many of us to be blinded into doing not what was in the best interests of the collective, our society, the Commonwealth, but what was in the best interest of various factions who were connected to people in power. We failed the most vulnerable. We failed ourselves in some ways. And now it's time for us all to work towards a better tomorrow. And by God, to me, if that means supporting Karen Read on this issue, and if that means advocating for Karen Read being able to get immunity, so be it. But if it takes the removal of all these pernicious forces within the Norfolk DA from these cases, if it takes Karen winning this motion to have the search of her phone prevented, if it takes Karen feeling supported, and all the other women who have tried to stand up to Aidan Kearney feeling supported, then by God, let's do it. You know what? Let's do it. Karen, you want to lead that charge? I got your back. Okay? Because I think it only because of who Karen Read was and how she was able to come to prominence was she able to be serendipitously enough, fortuitously enough, by fate, the straw that could actually break the camel's back and result in Aidan Kearney being held accountable, despite all, in my opinion, his connections, all his allies, all of it. It's Karen. It's Karen. And it's ironic enough, because I think there's some misogyny that does drive some of this. That's my opinion. It's ironic enough that it's the triumvirate of Karen Read, Meredith O'Neill, and Lindsay Cattani. They're going to hold him accountable. That right there. Can't predict how history is going to play out. You just have to write it. All right, let's keep reading. All right, here we go. Let's do it. We must uplift the downtrodden. God bless you, Troy. All right, here we go. Let's keep reading. The police may retain an item seized without a warrant for the relatively short period of time needed to obtain a search warrant. Seizure versus search, remember? But must release the item if a warrant is not obtained within that period. If the police fail to obtain a search warrant within a reasonable time, the seizure, even if it was reasonable at its inception because it was based on probable cause, may become unreasonable as a result of its duration. When officers fail to seek a search warrant, at some point the delay becomes unreasonable and is actionable under the Fourth Amendment. The Commonwealth bears the burden of demonstrating that the delay was reasonable. The Diaz court held that individuals have a critical possessory interest. Maybe there's some grammar rule, but I'm pretty sure it's a critical possessory interest in their cell phone. Sorry, I'm hyper-focused, you know. I'm a writer. We first note, quote, that the defendant had a material possessory interest in his cell phone. That's true. Quoting Riley, many who own a cell phone in effect keep on their person a digital record of nearly every aspect of their lives. Whoa! What's this? Karen's lawyer giving Lindsay a little help? He's winning me over. You see what he's saying? The Diaz court cites to White and Riley and says, like, a cell phone is a very special thing, and the courts presume it to be as such because it has a digital record of nearly every aspect of your life, so you have a special possessory interest and a privacy interest in it. Wow! Oh, shit. That has big, in my opinion, not a lawyer, it's not legal advice, that has big implications for what happened to Lindsay's cell phone. And I got to think Karen's lawyer was thinking about that when he wrote that. He's kind of giving Lindsay a wink and a nod. He's helping her. Because Tully released an unredacted extraction of Lindsay's cell phone. Except for messages from Tully to Lindsay and from Kate Peter to Lindsay, which he apparently removed. Maybe with Nick Garino's help, while the extraction was in MSP custody. And I really believe Tully released that so the public would focus on Lindsay instead of Jen McCabe. That makes it even more insidious. The Massachusetts Appeals Court, less than 1 month ago, held that a delay of 123 days, see, I knew this was going to come up, between the seizure of a suspect's cell phone and the first time the Commonwealth seeks a search warrant to search it is unreasonable. Yeah, this is way longer than 123 days. The judge ultimately concluded, based on these findings, that there is no legal precedent for finding a delay of 123 days to be reasonable, even with a compelling governmental interest. And because a compelling governmental interest is part of the due process analysis. That conclusion is today correct under Massachusetts law. The court further opined, and the compelling governmental, so they're going to lose no matter what, because the Norfolk DA is going to argue that the trial, the ongoing criminal trial, was a compelling governmental interest not to search the phone, and that doesn't matter. That's what that ruling says. So I told you Karen's lawyer's strongest argument was coming. It's a very strong argument. She's going to win. They should just give her immunity now, in my opinion. She's the one, like, setting aside the O'Keefes, okay, who I think they are an important voice in this, okay? I'm not equating them to Jen McCabe or Tully or Kate Peter. Okay, I think the O'Keefes are an important voice in this. But you have to set aside any one voice, okay? And you just have to think where we're at. Karen's going to win this motion. Any reasonable person would be working with Karen. Like, just because you prosecuted her for John's death, any reasonable person would be working with her against Aiden. But I believe, Kate has always wanted Aiden to work with the state against Karen, just blindly, and I don't understand that, because first of all, you can't be that close to the situation and weigh the harms. I'm sorry, I'm being as absolutely compassionate as I can. You cannot be that close to a situation and weigh the harms objectively. You can't, and that's what happened. There was just this blind, obsession with getting Karen, to the exclusion of everything else. And it was wrong. I'm sorry, it was wrong. It was wrong. And she's going to win, too. She's going to win on this motion. The conclusion is today correct under Massachusetts law. And that's what makes it worse. Like, the fact that she is in a stronger position than Aiden, and they just won't give her any respect. That office hates her. You can tell. The Norfolk DA hates her on a personal level because the DA had his connections and Tully had his connections to the family and to Jen, to John's family and to Jen. It became a personal vendetta. And you wonder why I support Karen now. And I'm not talking about whether or not she should have repentance for John's death. That's not what I'm talking about. Supporting her because she was treated extremely unfairly. Regardless of what, she wasn't treated as a criminal defendant. She was treated as the enemy. I now get what she was trying to say. She just didn't like how she was treated. Now, you can argue, again, about her culpability for John's death. She has a point. They really saw her as the enemy, and it wasn't just because of what she did, it was because of who they knew. And they had a lot of power in their own right, that unit, Tully's unit, and the Norfolk DA. And they also had some secrets they wanted hidden. Sandra Birchmore, whatever. It was a den of vipers. And I'm not so sure Nick Garino getting hit by a drunk driver, as I mentioned, was an accident. So when Karen said to Aiden, she is scared of Tully's unit, I believe her. I think those guys are scary. They lit me up one time. They didn't pull me over, but I know it was them. And I'm sure they knew that I figured it out quickly. It was the day that... It was a weird occasion. Tom CPU will remember this. And I don't agree with everything Tommy says either, by the way, as a disclaimer. Just, try to talk to people as humans, even if they have their own things or whatever. So anyway, it was the day Tommy went to the Canton police chief to have some meeting before he did his 24-hour standout. Now, unrelated to that, I was down in Brockton or something getting my medicine, because it's really cheap if you go to Brockton. And I'm driving up 24, and I take the fucking exit onto 93 south to hook up to 128 north. And I'm driving that little loop there, and I'm coming down where it goes from exit 4 to 3 to 2 to 1, or 2 to 1, and then up to exit 27, 28, 29. And I see Tommy, because he has a very distinct car in the right lane. He's got like this like wing. It's like an 80s style convertible, but it's got like winged kind of like doors with a unique window hatch. So anyway, I look over and I'm like, hey, that's Tommy. And then I put it together. I'm like, oh shit, he must be coming from that Canton meeting because he had posted about it. And I was like, oh, that's serendipitous. Like, it was just really like me having to cross his route. Okay. He takes exit 29, and he will be able to, like, I never talked to him about this, but if you ask him, I'm sure he'll remember this. Tommy takes exit 29A over to Dedham, which I think is Route 1, like, north or whatever the fuck, heading towards, like, Dedham Center and Boston 25 or whatever. I stay in the left lane of 128 North, and I'm going up to Route 2, so I'm just going to stay and whatever. And I'm in the left lane. I'm only going, like, 50, 55, because I'm coming down that hill and there's traffic anytime you're merging from 93 onto 128 where the split is for 95 south versus going up 128 north, there's always traffic. So I'm only going like 55, and they both light me up. When I say two undercover state cars, one silver, one black, regular plates, both red, lit me up. And immediately I moved to the right because they were going like 90 when they fucking lit me up. They went from the far right of the highway by exit 29A all the way to the left lane of 128 North, and they lit me up immediately going 90. I pulled to the right because I'm like, what the fuck? Like, they must be going to a call or something. It's like, they're not lighting me up. No, they only used their lights to light me up and get me to move over. Then they just continued up the fast lane, didn't light anybody up ahead of me, didn't turn their lights on again, and didn't respond to anything. And I was like, all right, was it Tully? Was it Yuri? Was it Fanning? Who was it? Like, it was definitely them tailing Tommy and then giving me a little FU on my way up. So listen, that's mild compared to some of the shit I'm sure that unit's capable of, but I just wanted to let you know I was absolutely attentive to what happened there, and I was like, oh shit. But anyway, so when Karen's talking about her tactical posture, I think she's also thinking about, like, who's the real evil here? Like, is it Karen Read at the worst of the worst, okay? That I'm only willing to think that at its worst, Karen, in a moment of rage, there was an accident that she couldn't own up to, and she panicked and covered it up. Is it bad? Yes. Did it result in a death? Yes. Is it really, really serious? Yes. Okay, all those things are true. But do I believe that she intentionally murdered John O'Keefe? No. All right. Therefore, I think you have Karen Read in a position where she's like, listen, if they had just charged me, this is what I think she was thinking. If they had just charged me with whatever the original charges were and not indicted me, I would have found a way to work with them, whatever. But they wouldn't. They made me a villain, and so I had to really go on the offensive. And then I also think in her mind, she has those texts about Proctor that he sent about her. She doesn't really like women who are mistreated, and she then starts to come to feel, wait a minute, it's not just that they're like going after me and being unreasonable. There's like a vitriol to this. Like, they really hate me and they're abusing the system. Oh, and there's also other evil here. And then add in Aidan Kearney to this, who I always believe Karen has thought was a risk. And you've got to think to yourself, Karen's probably thinking, who is the real evil here? Is it Karen Read, who, worst case scenario, has her repentance? Is it what she did? Or is it this unit, the cover-up of Birchmore's murder, how Karen was treated, what Aidan was doing, or what Kate Peter was doing, Tully, Kraft, Jen McCabe? Are those people the real evil? And is that the point Karen was trying to make? That's why I'm sympathetic to her. All right? If you want me to lay it out. On balance, I am sympathetic to that perspective. Does that mean I absolve? First of all, I can't absolve her for anything. I'm not God. But does that mean that, like, I defend her approach to what happened on the night of January 28th into the morning of January 29th, 2022? No, I don't. But do I see her as morally culpable on the level of the state police, that unit, or Kate Peter, or Kearney, or Tully, whatever? No, I don't. I'm sorry, I don't. She played ball with a system that she barely understood, and I'm sorry, I don't see her as malicious as those people. I see her as being cornered into using tactics that were inappropriate in the context of the criminal justice system, but I'm sympathetic to why. If she didn't do that, they were going to railroad her. And I'm not saying she didn't need to take responsibility for her actions, but she didn't deserve to be railroaded. And I'm not saying she was framed. I'm saying they were going to try to screw her hard, like really screw her. They wanted to give her life. So I guess my point is, it's a clusterfuck of a moral situation. It's not really black and white, but that's where I come from. All right. And then also you have to think of the practical reality of it. You're not going to win this motion if you're the state. She's right. 123 days is too much. We're talking years, 300, 400 days. She's going to win. So you have to think about the practical reality of who do you have more evidence against. As a lay analyst, I'm not a lawyer. This is not legal advice. I'm analyzing this. Who do you have more evidence against? Karen Read or Aidan Kearney? You have more evidence against Aidan Kearney. Who will seal it for you? Karen. You're trying to fit a square fucking peg into a round hole by getting Karen to cooperate, by getting Aidan to cooperate against Karen. It's not a strong case against Karen. But you know what is a square peg in a square fucking hole? Karen cooperating against Aidan. See what I mean? Big stack evidence, little cooperation, 100%. Small stack evidence, Aidan's cooperation, maybe like 30%. But you can't make the right decision if you're biased. If you have connections, if you're too personally involved, you can't make impartial decisions if you're too close. People can rail on me all they want for my impartiality. I don't see it as a sin. See it as a virtue. First time I ever met all those witnesses in the parking lot, I says to him, listen, I'm sorry, I cannot be your ally. Told him straight up, I cannot be your ally. I'm here to document this. I'm an objective observer. I said it straight to their face. So that's how I feel. Over time, the square peg will fit. Sounds like a Squid Game challenge. All right, let's keep reading because we're going to do our 20-minute video break here in a sec. This was if you're just tuning in, we're reading Karen's motion, which, by the way, this is a bombshell because now that I actually read it, like she's going to win. She's going to win this. She's going to win this. And there's tactical implications if she wins it. If she wins this, no evidence from her phone. So, what do you do then? Well, you do what you should have done already. Work with her. Cosgrove's never going to do it, though. Tully's never going to do it. Need a judge to really appoint someone. And that's what's probably going to happen. It's wild. It definitely wasn't on my bingo card. All right, here we go. Let's see. The conclusion is today correct under Massachusetts law. The court further opined that our courts have recognized that some delay in obtaining a search warrant may be reasonable, whereas here the government interest in the seized item is critical, but there is no Massachusetts precedent upholding as reasonable anything remotely approaching the 123 delay in the present case. That was the what was it? Diaz case that we were just talking about. And remember, wait till he drops this. He's saving his strongest argument for last. Here, the Massachusetts State Police seized Miss Reed's phone on January 24, 2024, and did not seek a warrant to search its content until August 28, 2025. This is a gap of 582 days, nearly 5 times longer than the 123 days that the Diaz court held to be an unreasonably long time. The law is perfectly clear. The Commonwealth's request is well beyond untimely, and therefore the evidence sought must be suppressed. Boom. You're a fan of Karen? You should be jumping up and down right now because that's an impossible hurdle to overcome for the Commonwealth. Even if they argue that they had a compelling interest with the ongoing criminal case, they're going to lose. They're going to lose. They're going to lose because of that. The Diaz precedent didn't exist until August of 2025. It exists now. She's going to win. All right? I'm just telling you, this is an insurmountable barrier, in my opinion, for the Commonwealth. Conclusion. Ms. Reed's phones were seized on January 24, 2024. No action was taken on the allegations of WI until a year and a half after, when the Commonwealth penned this motion. Conveniently, the motion only came to fruition after Ms. Reed requested that her personal property be returned. Oh, it's almost like the state forgot to do it. That's what he's implying. Oh, and that's not an excuse. Only then did the special prosecutor indicate an intention to rummage through her cell phones in the first instance. The Commonwealth cannot claim they were merely waiting for Ms. Reed's trial to conclude before pursuing this action, because they attempted, this is what I was going to argue, they attempted to indict her before a grand jury while her first trial was pending. Yep, March of 2024. For the above reasons, and for those argued by defense counsel at the hearing of this motion, Ms. Reed respectfully requests that this honorable court deny the Commonwealth's motion and order Ms. Reed's personal property be returned forthwith. Yeah, she's going to win. Sorry, she's going to win. Easily. I can't stop somersaulting. Nunya is apparently rolling around doing somersaults. Well, yes, we have. This is what I like about this chat. We have some Karen Reed fans, some anti-Karen Reed people, some pro-Turtle Boy people, anti-Turtle Boy people, pro-Lindsay people, anti-Lindsay people, some pro-Kate people, mostly anti-Kate people. But there's just a nice mix. All right. Now, the next thing we're going to read is this decision from the civil case. But before we do that, how much do I have to read? Only 13 pages. Before we do that, Tal's voice needs a little bit of a rest. Are we 2 hours in? Yeah, we're about 2 hours in. So we're going to watch a 20-minute video here. All right. It's going to be an easy 20-minute video to get you caught up on the chaos involving the recordings of Karen Reed, Aidan Kearney, all that good stuff. And if you had a fun time learning about Commonwealth v. McCravey and seeing Karen's lawyers' arguments coming to fruition, this is Towel Stream. You can support this stream by liking the stream while watching. Apparently that really helps the channel. You can support the stream by subscribing. If you haven't subscribed, you can become a member. There are no ads here. There's no sponsors. It's a public information service designed to educate, inform, and entertain the wider public, such as to engender, coach, and public discourse and ward off the usurpation of our representative forms of government worldwide. This service only exists because of you all. I'm only going to be able to get to class this month because of you all. I've been really struggling, so I don't do this for money. A lot of people need to live, okay? I never will knock someone for wanting to stream and raise donations, but I also hope people won't do that to others as well. It's not a bad thing to want to provide people with information to help them make informed choices and participate in the public sphere. And maybe you can help with the donation, but a subscription to the channel. There's lots of ways. Tell your friends, tell your family. There are ways to help this channel and help Little Towel and the mission of this public information service, and you are absolutely welcome to take advantage of them. As to those donation links, though, I did see some requests earlier. I'll drop them in the chat. Give me 1 second. There's this new setting I have to deal with here, so give me 1 second. No promises. No promises. Oh, I figured it out. All right, so let me just drop these. I drop them every 2 hours if you're new to Towel Stream, but nothing that you haven't seen before. Those donations there. Kate Peter for a second, and we can watch some videos. Kate Peter was a private eye, okay, who worked for a man named Marty Kraft in the fall of 2023. Kate Peter kind of did some bad things, in my opinion. All right, she was involved with kind of treating witnesses that weren't very wealthy or connected to Brian Tully, like anyone who wasn't Jen McCabe. Kate Peter was involved with treating them pretty poorly. She spread rumors through Aidan Kearney about Chris and Colin Albert selling drugs out of their pizza shop. She, I think, knew about Jason Broyles' identity as Haley Walbrecht before it was revealed. I think Kate and Jason Broyles were friends for a long time before Broyles appeared as an FKR and Turtle Boy person. I think Kate and Tully were involved with the leak of Lindsay Gattani's phone extraction specifically to help their friend Jen McCabe. But yeah, I just think people should be careful about thinking just because Jen McCabe and Kate Peter and Brian Tully and Marty Kraft and Michael Morrissey and Ken Mello and Robert Cosgrove were trying to get Karen Reed, that doesn't mean that they were necessarily all above board or that they were trying to get Aidan Kearney. I think they were always trying to flip Aidan Kearney to get Karen Read, no matter what Aidan Kearney did. They didn't care what he did wrong. They just wanted him to give them Karen Read on a silver platter. Now, also remember, Brian Tully's unit allegedly was involved with the cover-up of Sandra Birchmore's murder, okay? And I think Tully's unit was worried all the publicity from Karen was going to expose the Birchmore cover-up. I need to be 100% with you on that. So, listen, these people, it's dark, young black economist. I'm telling you, there's some very, 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 very well-hidden secrets in the orbit of this case. Nothing to do with anyone but Karen, in my opinion, being involved with John's death. No. It was more what Canton had to hide. It was like that great book in the 80s in the documentary Midnight in Savannah. Oh, this is Midnight in Canton, folks. Let me tell you right now, serendipitously enough with the timing of John's unfortunate death, it was Midnight in Canton, okay? And that road, 34, that Fairview Road collision, unearthed not just secrets about Karen Read and John O'Keefe. It unearthed secrets that lay dormant within Canton and Stoughton for over a year, and it inadvertently, though it may have been, exposed some secrets that went back decades. Decades. We're talking some of these troopers going to high school parties, folks. Going to high school parties with Matthew Farwell, with Billy Farwell, with Robert Devine. How deep the rabbit hole doth go. These are uncomfortable questions. These are the reasons why we cannot look at anyone as a hero or a villain simply because of what they support. Simply invoking the name of justice for John O'Keefe does not mean that you are without sin. In fact, Kate Peter didn't even set up those 2 protests in support of John's family. That was Lindsay Gattani. And Kate Peter took credit. Why? Because Lindsay's not the type of person who would ever take credit. Kate took credit for them. When you see Kate Peter's soul bared for what it is, it's not pretty. And I don't judge looks. I judge souls. We're going to watch this video, though. It's a 20-minute overview. It talks a little bit about Kate and Lindsay and Jen and Tully. So let's do it. And let's watch it. I'm a little tired. Let me get it up on the screen for you here. Thanks so much, by the way, for everyone who's been tuning in. Listen, it's not always comfortable to speak the truth. And I'm not going to show fear or favor. So those of you new to this channel, whether you're Karen Read supporters or otherwise, God bless you. You know what? If you're just tuning in, if you're thinking, wow, I didn't know Grant was this way. Well, yeah, I've always been this way. And if you've been here a while and you're thinking, wow, I didn't know Grant would take this position, really, I don't think you should be too surprised. I've always just gone where my heart and my principles and what I feel the truth to be, where it takes me. So let's go ahead and listen to our overview. Okay, it's about a 20-minute video. This is our intermission. Okay, before we start reading the civil document. And this is going to give us a nice insight into what's going on with the recordings and the Aidan Kearney and Karen Read situation and all of that. Because remember, simultaneous to Karen fighting to prevent her phones from being searched, you also have Karen Read in a battle, a proxy war, with Aidan Kearney. And so let's go ahead and watch Tal's 20-minute video. I'm going to go ahead and add that to the screen for you now. And it should be full screen. Yeah, right. So you're going to get to see double towel. Towel yesterday and a hat. It's cold up in my office, so I have my sweatshirt on again. But you're going to see double towel. Everybody loves double towel, a little double towel action. All right? You're going to see towel pitching to towel. All right, towel, take it away. You got a towel. All right, let's do it. You want to be the man, you got to beat the man, and there is no better team in the AFC East right now, at least after yesterday, than the New England Patriots coming off of that win 23-20 up in Buffalo. Hello, Falkor Luck Dragon. Yeah, we'll take a listen to the colloquy between the Glairer and I. I mean, listen, we have very different styles, okay? I'm more like, I want to be a priest. He's more like, I don't know, he's like a shock jock, and he owns it. He, like, if you listen to him, he'll tell you, like, that's his style. Now, does that mean he believes everything he's saying? I don't know. Like, he's a little bit of a troll. But, like, on a human level, when you get through the polemics and speak to Will instead of the glare, yeah, he can be very kind. Do I wish he would take the time maybe to get to know some of the people involved in all this nonsense and kind of understand them on a similar level? Sure, but like, okay, you can't get everything you want, you know? So he's a little weird, in the sense that his rhetorical style and the way he engages in dialogue is a little bit different. It involves a little bit more ethos, a little bit more rhetoric than myself. I tend to use more like appeals to logic and things like that, so a lot of kind of pathos, structured logical argumentation. So it's a clash of styles, but I can roll with him a little bit, and I can, like, he likes to joke around, and if you take the punches in good faith, you know, the rhetorical punches, he'll reward you with kind of an authentic conversation. You just have to know the style of the person you're talking to, I think. And by the way, just as a general note, just because I talk to someone, like a host on a program, that doesn't mean them and I, that person and I, align on everything. In fact, for example, a lot of people critique me for being a supporter of President Trump, and they'll say, well, Grant, you know, yes, you don't like communism, yes, you're pretty, you know, moderately right now in terms of the political spectrum, but you don't agree with President Trump on 10 out of 10 issues, maybe 8 out of 10, so how can you support him? Well, okay, it's wrong to just demand an ideological purity test out of every person that you engage with, first of all. And the other thing is, you can't understand the full spectrum of perspectives on any given issue, person, or development unless you talk to people who you don't agree with. That doesn't mean you're condoning or promoting or endorsing everything that they're saying. It's a necessary component of the amalgamated perspective necessary in order to parse kernels of truth from polemical sort of rhetoric and thus reconstruct some semblance of what happened. That's my interest. It's not an academic interest. It is a universalized principle that derives itself from the Kantian categorical imperative as interpolated through sort of a Weberian or Hegelian structure of history in order to parse narrative from truth and then reconstruct that schema, the sort of suite of perspectives on an issue or person or series of events in order to pull out that truth. That's the discipline of critical theory in essence. I'm kind of a third generation critical theorist who applies those skills in the digital arena in order to reconstruct the motives of various actors or players in the situation. But it's really no different than Adorno looking at how Edward Bernays was weaponizing his uncle Sigmund Freud's mass psychology of mind to sell cigarettes to women in the 20s under the auspices of a social movement. You know what I'm saying? So it's similar style. It's a similar style, but I don't want anyone to think that I'm a partisan. I'm not. I'm a partisan for the truth. The primary purpose of the work that I do is to find truth and center that truth in the discourse of an otherwise vacuous, polemical, propagandized, and otherwise insidious public sphere. So anyway, thanks for taking the time to listen to that. Let's get caught up. JFK. Well, JFK, the snitch, I don't know who you are. I want to interview JFK, actually, and I want to interview Joe Flipperhead, too. So, open invitations to the JFK Show guys and Joe Flipperhead, who I sent a DM to if he wants to come on. Open invitations today for them to come on and have a little conversation. But yes, you are welcome here to chat in the comments. Just some general rules if you're new to the stream. In the comment section, you're going to see like a lot of blue wall of Justice friends. They generally enforce some baseline rules: no being derogatory, no being discriminatory, no sea lioning, which is repetitive, subversive questioning to troll, and then there's a few other sort of basic rules they'll remind you of. But as long as you're engaging in good faith, generally you'll be fine here. So yeah, welcome. Hello, Colleen Henry and Buck Towell, the ever-vigilant guardian of the American Midwest. He is clearly in NORAD. FBI, DOJ, corruption survivor. It is great to see you, my dear friend. Hello, Ruth Lang and Nancy from the 508. All right, now that we got that intro out of the way, and I am going to have a little bit more of my Gatorade. Messy, that's exactly what we're going to talk about. Okay, how should we do this? Let's start with the Jessica Leslie situation, okay? Well, yes, but Falkor Luck Dragon, I think the true measure of our ability to extend compassion is to be able to do so in the face of even egregious sin. Because I don't think anyone would redeem themselves in this modern digital hive mind based world if we all just constantly look for reasons to pass judgment and then scorn. Someone has to break the cycle and love the sinner and not the sin. So I don't know. That's my view on it. I'm not saying you have to adopt that perspective, but I don't necessarily feel that people's souls are defined by their specific actions in every case. Sometimes there's irredeemable sin, but that's really more for God than for us to judge. But on the whole, I don't feel that I feel it's possible to separate someone's actions from their soul, and that's how redemption happens, I think. Hello, it's so good to see you again, Ruth. Oh, it's the buck towel emoji. I'm pleased. All right, let's get into this. So, Messy, we are going to talk a little bit about, by the way, I got a new streaming setup. I shrunk the size of my monitor because it was hurting my eyes to look at the big monitor. So you got to give me like 5 minutes to adjust here. I now see your comments like directly in front of me, so I'm going to be a lot more interactive with the comments. Before they used to kind of hide. But we also have stuff to watch, all right? So I got to do my summary as much as I would love to answer all your questions. How about this? We will set a segment aside for questions at a certain point, but as of now, when I just look at your questions, it makes me want to answer them all. Hello, Jerry. Very good to have you with us. Welcome to the chat. But let me dive into this a little bit. Okay, so last week, what was going on? Jessica Leslie got sentenced. Now, I actually have a video for us to watch because I want to talk today, but I want to talk the least amount possible because I'm not feeling well and I'm physically ill. Okay, so I'm going to play a lot of my videos that are already recorded, and then that will provide our background, and then we'll go from issue to issue. So this all ties in. Remember, there's a lot of stuff going on. There, if you watched the stream last week, I did a short stream about the Aidan Kearney and Karen Read recordings and how that was bubbling up because Joe Flipperhead was on an X Spaces with this guy who thinks he's a koala, and then this other Australian woman named Lily, and Joe Flipperhead and Aidan Kearney got into a battle, and in the middle of the X Spaces, Joe Flipperhead got permission from Karen to release information that Karen was recorded while talking to Aidan, and then someone sent it to Karen's lawyers. Okay, then the next day, like a limited hangout happened, and like 8 of the clips from a recording of Aidan and Karen talking got released, and they were very specific type of clips that didn't really make Karen look bad, they made Aidan look bad. Now this has crescendo to the point where then Karen went in the JFK show chat within the past few days, and then started saying she was recorded without her knowledge, and there's more that's going to come out, and there's people she wants to talk to. Basically, this is running in parallel to a number of subsequent developments. It really started, I'd say, late August or September of 2025 when Robert Cosgrove, the special prosecutor on the Aidan Kearney cases and apparently the potential Karen Read cases, announces in a court filing that there is an open ongoing investigation related to Karen Read and Aidan Kearney, or at least related to Karen Read, that Cosgrove was aware of. Now, who's doing this investigation? If it's a federal investigation, a state investigation, I don't know. I don't want to know, frankly. But anyway, Cosgrove writes that. Okay, then I'm reading Defense Diaries Twitter on like Friday night a few days ago, and Defense Diaries is this, I think it's Bob Mata, I don't know. It's one of these lawyers. So he puts up this affidavit from Betterow, Mark Betterow, Kearney's lawyer, one of his lawyers in criminal cases. And Betterow writes this affidavit. It's a little bit of a ridiculous affidavit, but in the affidavit there's some like kernels of gold. One of them is Betterow just says there's an open investigation of Aidan Kearney and Karen Read. And I'm like, Betterow, what the hell are you doing, bruh? Why are you saying that? So anyway, that's kind of what's going on, right? That's like the real world developments. And then you got the online drama related, I wouldn't call it drama, it's very substantive, related to the recordings and the Free Karen Read camp kind of splintering, and Kate Peter telling people that she wants them to support Aidan Kearney because Aidan Kearney apparently might have information that would allow his charges to go away if he flipped on Karen Read so that Karen Read could get charged with something new. It's wild, all right? But think about the parallel developments there, okay? You have the situation with the criminal case and the potential investigation into Aidan and Karen. Then you got these leaks by Karen. And then you got this online war for the soul of the Free Karen Read movement. What's happening? I happen to think Karen's a tactical genius and got ahead of what she saw was going to be a play by Aidan Kearney, Kate Peter, and the state, the Commonwealth and the state police to drop all of Aidan's charges if Aidan gave up Karen Read so that Karen Read could face more criminal charges. Witness intimidation, 268.13b, conspiracy, 274.7, etc., etc. Now, Karen Read, for whatever reason, has these like intel connections. I don't know why. I haven't really figured that part out. It kind of baffles me a little bit. But Karen Read is very smart, and I think Karen Read got ahead of it. And part of why I'm so upset is that I think there's this pattern, okay, of women in Aidan Kearney's life that he gets close to, whether he gets with them or doesn't get with them, and then there's this kind of transactional relationship, and then he thinks that he can control them. It's a playbook. That's my opinion. I've seen it play out a few times, okay? There's evidence of this. And I don't, listen, I don't like when that shit gets run on someone who's just of the regular class, okay? You want to talk about the movie Metropolis and the people up in the garden above the cities and then the fucking working class. You run that shit on the working class, you're going to piss me off. Not because I'm a damn communist. I don't like damn communists. But because you don't treat people like that. I don't care if they have millions of dollars or $10 fucking dollars or negative $50. You don't treat them like that. That'll piss me the fuck off. But listen, you run that shit on Karen Read, who's a savvy, diplomatic, political operator. That's more than just offending her, bro. That is going to bring out in her a tactical side that you are not going to like. I wouldn't fuck with Karen Read like that, okay? Like, yes, I'm a strong critic of Karen Read, but I wouldn't disrespect her. One, I'm not a misogynist, so I would never treat a woman as less just because she's a woman. And two, she's a genius. Just like with men, there are some women that are like really smart, some women who aren't so smart. It's just a, varying whatever. Not everyone can be in the top of the bell curve, all right? Karen Read's at the top of the damn bell curve. And that's kind of why I'm cheering her on here. Not because I agree with her version of what happened on the night John O'Keefe died. I don't. At all. Please don't mistake me praising her about what's happening now for praising her about that. I'm not. I do think she's smart enough to have covered it up in real time, which that's... It's on another level. You gotta be really smart to do that in real time. That doesn't mean I'm okay with what she did. But what she's doing now, because of how everything aligned, because of how Aidan Kearney, in my opinion, hitched his wagon to Karen Read, there's only one person that can stop him, and it's Karen. And Karen, in my opinion, never talked to her, she doesn't like when people take advantage of women, especially people in positions of power like law enforcement. So how do you think, I think Karen tolerated some of what Aidan was doing, but I don't think she ever liked it. I don't think she was ever comfortable with how he treats women or how he acts. And then he ran the playbook on her over this last week. And this was outside of Lindsay Gattani, who I think over 18 months came to a similar position as Karen Read, okay? But Lindsay Gattani is not from that world, okay? Lindsay Gattani was a nurse, worked Stop and Shop, just kind of a working class single mother, okay? Karen Read was a fucking financial academic power play. Okay, so you run that shit on somebody like Lindsay, she might be able to learn how to play that aristocratic political game over time. You run it on Karen, she already knows what you're doing the second you send that fucking email, whether you tell her that it's from you or not with the recording. She's going to know if the recording is real. She knows what the conversation was like, so she's going to know right away. The reason why I think Karen's moving on Aidan right now, in my opinion, is because that recording is real. She knew it was real. She took it for the message that it was, and instead of playing ball, you don't play ball with someone who, in essence, whoever it is blackmailing you. You want to stop someone from blackmailing you? You go out in the public and you're like, hey, someone's saying this shit to me. Fuck them. And then you burn them. And that's exactly what Karen Read did. So don't underestimate Karen Read's tactical intelligence. It's too good. You know what I'm saying? Michael Diamond asked, do you think Aidan tried to catch the glare up with a charge at the pizza shop? He did the same thing with Meredith showing up at Higgins in August. Someone said that to me, said Michael Diamond. I don't know. It's an interesting theory. I don't have enough information to pass judgment either way. If I got more information, I can tell you an answer to that, but I'd have to hear it like from somebody who was directly involved that had information that they felt it made it a setup. I don't doubt Kate Peter uses those tactics, so it wouldn't surprise me. But I don't know enough about those two situations to say that that's why Aiden brought the glare to the pizza shop, or that's why Aiden brought Meredith to the Higgins thing. I don't know. I just don't know. Allie and Rue. Hello, Allie and Rue. They say KR is an evil genius. Christina said, I want Karen to be held accountable. Well, yeah, but Christina, it could be a zero-sum equation. I think my biggest concern is people saying, well, it doesn't matter what Aiden Kearney did wrong or what the people victimized in those cases think. It's important to get Karen, so let Kate Peter wheel and deal with Aiden, make all of Kate and Aiden's criminal charges go away, and then get Karen. Okay, what? And especially if that only happened because Brian Tully and Kate and Jen McCabe and Michael Morrissey have this weird, personal relationship. You got to think about the timing. Morrissey recuses in October 2023. Then immediately Mello starts up the grand jury, but Mello's talking to Kate. Kate's talking to Tully. Tully's talking to Jen McCabe. It was basically that was Kate and Jen McCabe's personal prosecution of Aiden. Now, I do think the reason Tully and Mello went along with it, and the big guy Morrissey went along with it, was because Morrissey wanted to flip Aiden to get Karen. So that, you can argue, is within the remit of prosecutorial discretion. What's not is giving Jen McCabe and Kate Peter a personal prosecutor. I shouldn't laugh, but it's really not. It's not acceptable. Whatever you think about the underlying charges, the whole way that was approached was wrong. It was an abuse, and it compromised these cases. Listen, the reality is, in my opinion, the cases against Aiden Kearney and Karen Read were compromised years ago. And the whole problem is, it's not the crime, it's the cover-up. So it wasn't that Kate Peter was involved with handling of evidence and doing all this weird, shady shit for the PI, Marty Kraft and Tully and Jen or whatever. It was that the rules of evidence don't matter if you're never going to bring something to trial. So I think Tully was telling Kate, hey, this shit doesn't matter. Whatever the fuck, we'll release Lindsay's phone extraction. Then we'll just do all this other shit. Nothing matters. We just want Aiden to flip anyway, so it's not going to trial. Who cares? The only punishment is the exclusionary rule, the evidence being excluded from trial. So what's the harm? That's exactly the conversation I think Kate and Tully had. The plan was always to get him to flip. That's wrong. That means these cases could never have gone to trial. Back as early as October, November, December 2023, Kate's participation and her handling of evidence and Tully just submitting evidence from Kate to the grand jury, the cases were never going to be able to go to trial, which means Tully and Kate are looking for a fucking scapegoat right now, which is bullshit. They should own up to that shit that they did. They compromised the cases, and in my opinion, they only did it because they never were going to bring Aiden Kearney to fucking trial. It was all for the purposes of getting him to flip on Karen. Fucking ridiculous. It is wrong. It is a conflict of interest. They should never have had MSP officers on either of those cases who knew people that were personally involved as witnesses or whatever. MSP should have recused that unit. We could have had MSP involved, but that unit detailed to the Norfolk DA should have recused itself from this whole thing. It was because, although Morrissey recused, Tully was left on the case, that Tully used Kate as a medium, an intermediary, to facilitate the Norfolk DA coordinating this nonsensical plan to put pressure on Aiden Kearney so he would flip on Karen Read. That's what happened. All right? Now, what I would like to do is I'd like to pull us back. We're going to watch some of this stuff. We're going to talk about it. We're going to go till about 12, maybe 12:30. The first thing I want to show you is my coverage from outside the courtroom after Jessica Leslie's sentencing. Now, this will explain to you who Jessica Leslie is, of course. But Jessica Leslie was the John O'Keefe and Karen Read federal grand juror leaker. Now, we're going to talk a little bit about how Jessica Leslie, in the sentencing memo from the government, the DOJ, Jessica Leslie is basically forced to admit that she leaked information over the course of a year or a year and a half about two cases. One, the CDL case, the Massachusetts State Police CDL bribery case. And then two, the Karen Read and John O'Keefe case. And she's forced to admit that she gave the information to a friend who then leaked it to people on social media via DM. Now we're going to watch my coverage, then we're going to watch a video of Jessica Leslie's mother, the first public footage of Jessica Leslie, known to exist, of her and her mom yelling at me, and then she calls me a towel. Then we're going to watch a video of Aiden Kearney talking about how he was messaging with Leslie's friend, and when he went on live stream to look at their messages, her profile was gone and all their messages were deleted. So let us go ahead and watch the little towel video. You know why? Because I'm a little towel. All right. Hello. My name's Grant Smith Ellis. So now we're going to read the civil motion, or the decision from the Karen Reed and John O'Keefe civil case. But just to answer Bossy Texas Chick's question, no, Bossy Texas Chick, I think Kate Peter and Brian Tully compromised the evidentiary chain against Aiden Kearney a long time ago. They were never, in my opinion, intending to take Aiden Kearney to trial. No, it was all a pressure tactic to get him to flip on Karen. So the rules of evidence? Oh, God. First of all, I think Brian Tully might know what they are, but I'm not convinced that Kate Peter even knows what the rules of evidence are. She flagrantly violated them, in my opinion, multiple times. She deleted evidence that Tully submitted to the grand jury. This Kate Peter's out of her mind. She never should have been allowed near that prosecution. So, Bossy Texas Chick, please let me just lay it out for you. That prosecution of Aiden Kearney was compromised in 2023 by Kate Peter and Brian Tully, who never intended on bringing Aiden Kearney to trial, which is the only reason they would act so flippantly with regards to the handling of evidence, because the only punishment under the Fourth Amendment, as we just learned in Karen's lawyer's extensive motion response, is exclusion of the evidence. Therefore, if Tully and Kate weren't worried about the Aiden going to trial, the evidence was never going to be excluded because there was never going to be a trial. They compromised that prosecution to begin with. They were looking for a scapegoat the whole time. Michael Proctor, ring a bell? John Fanning, ring a bell for Sandra Birchmore? When are people going to realize Tully and Kate are no good? Just because they prosecuted Karen Reed doesn't mean they are good people. They compromised the Kearney cases. They've been looking for a scapegoat for years. They literally leaked Lindsay Gattani's phone extraction. And yet some of you, I don't understand why, because Kate Peters says the words justice for John O'Keefe, it's just like, well, who cares if she leaked Lindsay's phone extraction? Who cares if she's evil? She's a fucking serpent. It's the most dangerous kind of evil. It's the serpent who hisses out of one fucking mouth while smiling with the other. So that's why I'm so insistent that folks realize that this was Kate Peter and Brian Tully who compromised these cases years ago, because in my opinion, they never intended to charge Aiden Kearney. It was all to get him to flip on Karen Reed. That's why they compromised the evidentiary chain. All the new discovery, all the motions from Betterow, they are mostly about how Kate Peter compromised the evidentiary chain. And then you also have to realize Jen McCabe told Lindsay that Lindsay needed to be sorry for dating Aiden and supporting Karen Reed at one point. Okay, you don't understand how much power Jen McCabe thought she had, in my opinion. Okay, this was a personal prosecution for Kate, right? And Jen, with Tully's help, with Morrissey's tacit approval, using Ken Mello and Robert Cosgrove. It was compromised years ago because they were never going to take it to trial. So Kate Peter is, first of all, should never have been involved in this. People have to understand this. Second of all, she is the primary reason why these charges were never going to go forward. I'm shocked they even let it get to this stage, because the discovery just humiliates Kate and her PI boss Marty Kraft and Tully and Morrissey. It makes them all look like amateurs. That's why I called Tully Lestrade. And then they have the gall, Kate and her people, to go insulting Lindsay, calling her names and blaming her. No. That girl stood up for herself, in my opinion. And they want to make her, like they made Michael Proctor, the scapegoat for their bad behavior. Nope. The buck stops with Brian Tully. He was the commander of that unit. The Sandra Birchmore cover-up, the buck stops with him. The release of Lindsay Gattani's phone extraction, Tully did that personally. The buck stops with him. Kate Peters' tomfoolery, the buck stops with Brian Tully. Jason Broyles' behavior, the buck stops with Brian Tully. And until that man is hauled in front of a congressional committee, I'm not going to stop. All right? He needs to answer, in my opinion, for what he did. And I want to know why. No more bullshit. No more lies. No more blaming Lindsay. No more obfuscation. No more bullshit. I want answers. I don't care what they are. I just want answers, and I deserve them, and the victims deserve them, the public deserves them, the taxpayers deserve them. If they spent a single dollar of taxpayer money on Kate Peter, so help me God, there needs to be an audit. We have a right to petition our government. We have a right to have our tax dollars accounted for, and what they did was wrong. And I don't want to hear any of this nonsense about how it was anyone's fault but Kate Peter and Brian Tully. They know what they did, and Jen McCabe, and Michael Morrissey, and Ken Mello, and Robert Cosgrove. Let's talk about it. Sinead O'Connor was ahead of her time. You know what I'm saying, bossy Texas chick? So is Towel. Oh, yes, I agree, Beach Dance. I'm not saying two things aren't true at once. I'm just saying Kate's motives were impure. And you can't, that's why Aidan Kearney has been acting with impunity. We talk about, in my opinion, why does Aidan Kearney keep getting away with stuff? Why does he just go around acting with impunity? Because they don't want to charge him. Because they want him to turn on Karen. That's what gets me. Gets me riled up. And then people are like, Kate's got the gall to go out there and attack Lindsay. How dare she? Kate, I'm shocked Kate has the gall to speak in public with those ops she ran. Shameful. Shameful. If she had a conscience, it would be tormented. I don't think she has one. She told me to my face religion is BS. I should have said back, say that to Miss O'Keefe. Instead, I just stared at her. Like, what the fuck, you heathen witch? I didn't say that, but did you just tell me my religion is bullshit to my face? What the fuck? Who says that? What kind of even if you don't believe in the person's religion, who says to the person's face, clearly I'm very religious? Who just says religion is bullshit to someone? That's how dark that personality is. Don't even want to tell you about some of the other shit she's done. I don't take it personally, bro. The only thing I really care about, like, safety, country, God, family, in that order. So, like, the only thing you'll get me really riled up over is if you threaten someone's safety, if you threaten my country, threaten my God, or if you threaten my family. Kate Peter has hurt people I loved. I love. Kate Peter has caused so much pain. I don't even think she understands the amount. Like, I don't think people's tears matter to her. Maybe if they have money or something. I don't know. But I don't think people's tears matter to her at all. I don't think she understands the extent of the pain she caused. Or that she enabled Aidan to cause. Or that Tully caused. I don't think they fucking care. I think they're completely hardened to it. That's what fucking pisses me off. Human tears matter. Alright? But not to them, they do. They don't. I think they look at pain as a source of, like, they thrive on that shit. Kate loves the concept of, like, humiliation, tormenting the vulnerable. That's fucked up. You thrive on that shit, in my opinion, something's really wrong with you. And I believe she thrives on it. And I kind of think Tully thrives on it a little bit as well. Not as openly. Like, I think he's one of them, like, you know, too cowardly to go stand up there and say how evil he is. But I think him and Kate are very similar. I think Kate and Aidan are similar than they want to admit. They can pretend all they want that they're different. But they think very similarly. They think very tactically. And they're very numb to the impact of their behavior, in my opinion. Like, I kind of feel like what we have to do is, part of this is just the humanization of it, right? Like, so the weapons, in my opinion, that Kate, and that's what makes them different than Karen. Karen uses narrative, but she doesn't necessarily dehumanize. A lot of you are going to disagree with that, but she doesn't. It's not the same. Kate and Aidan dehumanize. Like Lindsay Gattani, if you would just relied on Kate Peters' descriptions and Aidan Kearney's descriptions, Lindsay Gattani would not be a human to you. But you read Lindsay Gattani on Twitter, she's just a regular human. She's really smart. And she's funny and amiable and all that. But that's what I don't like. It's the dehumanization in an effort to discredit. All right? That's what I think Tully, that's what I think Aidan, that's what I think Kate, they all share it. They call it the dark triad personality type, but I'm not smart enough to figure that stuff out. All I know is there are certain themes of how these people act, and it always is centered around, like, manipulating the vulnerable, taking advantage of people without money or resources, some kind of systemic power, like destabilizing emotional techniques, like always keeping the person that's the target of your operation in fight or flight, public humiliation, finding out derogatory information about them, alt account, like fake alt accounts online. There's this playbook. It's so well studied. It's like they claim that it's like they all feel they're coming up with it for the first time, when really they're just repeating the same tactics as every other fucking dark triad personality. I'm not saying that's what these people are, but their tactics, you can trace them, and that's how you find the real evil, in my opinion. That's just how I analyze it. It's also why I don't see Karen as quite as evil as Aiden and Kate and Tully. I'm sorry, I don't. She doesn't have that. She has more of like a fight to protect yourself drive. It's different. And then someone asked earlier, they were like, oh, I don't really trust the judges necessarily. This is just a comment from someone in chat. I don't necessarily trust the judges, Grant, but I really liked your faith in Karen's motion. Yeah, I mean, I'm not just gratuitously cheerleading her. And that's what I'm saying. If you're hearing me say it, it's not because I'm just saying, oh, I love Karen Reed. Like, no, I support her where she's being intelligent. I'm telling you that motion's intelligent. And on that third prong, the 500 and whatever it is, 26 days, with the Diaz ruling, she's going to win. It's in my opinion, I'm not a lawyer. This is not legal advice, but she's going to win. It's black letter law. She's going to win. There's nothing the government's going to be able to argue, unless there's something I'm not seeing, which is always possible. But there's nothing the government's going to be able to argue in a reply or at oral argument that's going to override the Diaz precedent, and she's going to win. And if she wins, look at what people are saying in the poll we have. Who should be given immunity in exchange for cooperation with the state? 62% of you say Karen Reed, she's the chosen one. 38% of you say Turtle Boy, Kate always wins. So, you know what I'm saying? I think a lot of people are already leaning that way. And if she wins this motion, and if it just keeps coming back to me, like for me, what it comes down to is, the Norfolk DA should not be involved, and they should not be picking special prosecutors for this. The statute isn't. I might have to go to Beacon Hill about this, because the statute isn't really written. If you read the special prosecutor statute, it's not really written for this type of situation. It's more like if you want the DA to appoint someone, then you have a special prosecutor. But that's not what we want. I'm saying we as in the public. That's not what's in the public interest. We need a special prosecutor statute that doesn't involve the DA who's recusing themselves picking the replacement. That's the breakdown here, okay? This is what I do. I am petitioning the government as a citizen to change the statutory framework because I don't like how this is functioning. It's a serious issue. Now, listen, the judges can fix it. And this is why when I say it falls to the judges, you have to think of the pyramid of laws, okay? You have laws which are written by the legislature, okay? Now, those laws control regulations and then etc. That's the hierarchy. Now, parallel to that, you have judicial decisions which interpret laws pursuant to their constitutionality and their plain language and all of that. And then you also have judicial decisions that kind of fork off into what's called common law. Now, common law, absent contravailing legislative precedent or interpretation, common law has the force of law. Judicial decision, judge-made law, judicial decisions, judge-made law, can fill in gaps where the legislature didn't anticipate something or hasn't addressed something. This is one of those situations. I'm telling you, the special prosecutor statute is broken, and we're running headlong into this situation. We're going to get common law where a judge, probably one of the judges in Norfolk Superior Court, is going to have to create this new thing. It's been done before, but really we need a new law for this. There has to be a situation, there has to be a law for when a DA is completely recused, the whole office, and a special prosecutor has to be appointed that doesn't involve the DA in question or any DA picking the special prosecutor. Now, I think the judge in the Kearney case is just going to do it. I think all of the judges in that courthouse, by how they've treated this case, they smell a rat. They don't like it. It's some tomfoolery. It's an abuse of prosecutorial discretion, whatever the hell is going on. And they want to take that office off this case. You already saw Judge Doolin basically do that. I think we're going to see something very novel fashioned by the Superior Court the judges of Norfolk Superior Court to resolve this. I'm telling you, we're going to see something very weird. It's not going to be the charges going away. It's going to be them addressing this gap in the statute, the special prosecutor statute, because really Michael Morrissey should have no say, and his office should have no say in who prosecutes Aidan Kearney and Karen Read, or either or. Okay, he shouldn't. It's too much of a conflict. And it's not a conflict because he prosecuted Karen Read. It's a conflict because of who he knows and who Tully knows and his relationship with Kate and all that stuff. They compromise themselves. They have to get off that case. The judge doesn't really have a statute to rely on. Aidan doesn't have a statute to rely on. There's no statute that can compel a district attorney not to appoint the special prosecutor. The statute, in fact, only allows the district attorney to appoint a special prosecutor. We need a judge to come in here and basically create an exigent circumstance, basically, where the DA cannot. And so judge is going to have to do it. But it shouldn't be judge. There should be a statutory framework for what happens in this situation, and we don't have one. And I don't like it. All right, so let's continue. Here is the decision in the O'Keefe and Read civil case. Now, we already knew judge's decision, but we didn't actually have the memorandum in order. So this will actually enumerate everything judge has to say. No, this isn't a motion, it's an order. So we're going to learn a lot. Everybody buckle up. You ready? Everybody ready to learn? Who's ready to learn? Judge is going to teach us things. Who's ready to learn? I'm a little towel. Everybody ready to learn? Everybody excited? Nothing quite as exciting. All right, here we go. This matter arises, well, I shouldn't say it's exciting. It's also going to be sad because we have to review the facts of John's death. But if you are into law, I'm not a lawyer, this is not legal advice, but you're going to learn a lot from this. All right, so we got to balance the fact that we like learning with the subject matter. All right. This matter arises out of the January 29, 2022 death of John Joseph O'Keefe III, JJ, defendant and moving party. Karen Read was previously charged with several crimes in connection with JJ's death. During the pendency of Read's criminal case, plaintiffs Margaret O'Keefe, Margaret, JJ's mother, Miss O'Keefe, that's what I'll say, John O'Keefe II, John, JJ's father, Paul O'Keefe, Paul, JJ's brother and personal representative of JJ's estate, and Kaylee Furbush, Kaylee, JJ's niece, who is a double orphan, triple orphan now, which is heartbreaking. And John adopted Kaylee and her brother after their mother and father passed away in November of 2013 and January of 2014, respectively. It's a very sad story. God bless those kids. It's what makes some of this so hard. I'm telling you, I'm not unsympathetic to why people have such a personal stake in this in so many different ways. It's just, I'm a policymaker, all right? It's not the first time I've had to seriously think about a lot of very painful interests, a lot of painful experiences, and craft I'm an analyst, okay? I weigh in. I'm a member of the public who can petition the government like anyone else. But it's really hard because I think about it from the perspective of policy. I can't think about it from the perspective of what's going to be the best to help Kaylee. I think someone should be doing that, but that's not my role, okay? It's very similar with anyone else, okay? At no point in time is it my role to be saying this is what's in this person's best interest. I have to analyze it from a policy perspective. And so that's what makes it so hard. How can you look Kaylee in the eye and say you're not sympathetic to what's happened to that poor girl? Not only that night, not only because of what she had been through before, not only because how she was treated, although she was tormented, but not as much as other people, thank God, but just what she had to go through. You know, the week she testified, that was one of the only days in the second trial I did it for her. And I took notes, and it was blacked out in the media, but I took notes, and I really wanted to get her voice out there because I thought it was unfair that people were distorting her testimony in the first trial because there was no recording allowed, so you had to go on the reporter's notes. And I think I don't know Kaylee, but I think she's very brave. And also, One of the anecdotes that will stick with me is that week she testified. I think she testified on a Tuesday or a Wednesday. That Friday or Saturday, I was reading social media. It was either one of the groups or Twitter. It was something shared publicly. And someone was like, she hit a home run in her softball game. And you got to think of the headspace you have to be in on a Tuesday or a Wednesday, even with no cameras, to testify in a criminal trial about the loss of your adopted father, basically. She didn't cry on the stand. Not once. Not once. Now, as soon as she walked out, the back room, like it's a courthouse where it's courtroom 25. It's very small. She walked by the jury, got out of view of the jury, walked towards me to leave the courtroom, and when she took the turn out of that back kind of cubicle vestibule to take a left to go to the door, then she started crying. But she did not cry the whole time she was on the stand. And you got to think of the headspace you're in to have to be able to do that. And then go to your regular life as a high schooler, okay? I don't think anyone gives this girl enough credit, Kaylee. And I'm just using this anecdote to spell it out because she has to live every day with this. But to go from that to being a high schooler and then to go to your softball game on Friday night and hit a home run. I mean, she must have, crossed that plate saying that was for you, John or JJ, however she referred to him. Because that's incredible. Like, to be in that headspace, to be able to do that, to be able to show up to the game, not to mention go to bat in a competitive game and then hit a home run. It shows her resiliency. She doesn't get enough credit. People don't talk about her enough. I hope she gets to tell her story eventually. And it's what makes it so hard. I don't want to sit here, and it must sting a little bit, but all I can do is explain my perspective. I don't want to sit here and make it seem like I'm diminishing what happened to Kaylee or John's family or John. I'm not. This became political, and completely against anyone's will. I don't think John was very political. He was just a noble man who served in a very tough unit of the Boston PD, and he went after really bad guys, and he held them accountable. Very unsung, noble man. Okay, I don't think he was political. Karen made this political. Okay, and I'm not blaming in any way, shape, or form the O'Keefes for what they went through. They did not choose to go through this. It's an unfortunate reality. There's a difference and a distinction between normative moral analysis, what we want to happen, and descriptive analysis, what is happening. And that's why you cannot always, and this is what makes it so hard, create policy from a normative moral perspective, especially particularized to a specific individual. You can't say in every case, although it does apply in some cases, but you can't say in every case that what's right, what will do right by Kaylee, is what will do right by every single person in this situation. And that's not to discount what happened to Kaylee. It's a fact, it's emphasizing how important what happened to her is in the resolution of all this. But I'm just cautioning against making policy from the perspective of any one person's interest. That's literally how I see my analysis here. And so I just wanted to pause and say that because I think it induces cognitive dissonance for a lot of people. Hearing me talk about the unfolding developments with the Turtle Boy and Karen Reed clash and how I'm thinking about the potential ruling on the search of Karen's phone and how I'm thinking about who should be getting immunity and who could cooperate. It's going to sting a little bit, but it's not a black and white moral picture. I would be abdicating my duty as an analyst if I were to not take into consideration the full picture. And you can see it in the chat. There are a lot of people who are very, very supportive of Kaylee, regardless of where you stand, and that's redeeming. Oh no, bossy Texas chick, I'm not gonna shed tears for anyone in particular, for Karen or otherwise right now, because I don't think that's where we're at. But I do think it's important for me to emphasize, I have seen people, for the most part, not torment Kaylee. Now, I'm not saying Kaylee's claims aren't strong. We're going to read about them. I'm not a lawyer. This is not legal advice. We're going to read about what Judge says about them. They're strong. But on the whole, I think we should all take a little bit of solace. And maybe we can do better, okay? Whether you support Karen, Aiden, or don't support Karen or Aiden, or whether you support one or not the other, it doesn't matter. I think it would be great if just the whole discussion of this was in support of Kaylee. Now, is that necessarily going to make Karen feel great? No. Okay, but like, Kaylee's the one person who, one, thank God, people haven't really tormented. I'm not saying that there hasn't been people targeting her. Anyone who's doing that or who has done that should feel very bad. But I think it would be very redeeming if what came out of this was, at least for Kaylee, a lot of unifying support. She deserves it. If you think about it, do you hear a lot of people out there like talking about Kaylee? No. I hope they do start doing that soon. I've heard on social media and various posts, after she graduates, gets a little older, she will tell her story, and that's important. And how great it would be, regardless of how you feel about the case, if the reception to that was just, compassion. And if you've ever asked for that kind of compassion because you're talking with someone who you disagree with and they showed it to you, maybe we can all make an effort to show it to Kaylee. And that's kind of the point I wanted to make. Just because I can't create policy solely from the perspective of what's best for Kaylee doesn't mean that I'm not very sympathetic to what she's been through, and that we all should not be sympathetic to that as well. In fact, I'm encouraging us to be sympathetic to that. So, thank you for listening to my rant on that. Let's continue. Filed this civil lawsuit asserting claims against Reed for wrongful death, count 3, negligent and or reckless infliction of emotional distress, count 10, 11, and 12, and negligent, reckless, or intentional infliction of emotional distress, count 13. The plaintiffs also asserted claims for wrongful death, counts 1 and 2, and negligent infliction of emotional distress, counts 4, 5, 6, 7, 8, and 9 against CNC Hospitality, LLC, doing business as CF McCarthy's, GS Hospitality, LLC, doing business as CF McCarthy's, collectively CF McCarthy's, and Waterfall Bar and Grill Limited, doing business as Waterfall Bar and Grill, Waterfall. These defendants are corporate entities that owned bars that allegedly serve Reed alcohol in the hours leading up to the events at issue. Reed filed a motion to dismiss all emotional distress claims asserted against her. CF McCarthy's and Waterfall joined on Reed's motion to dismiss, similarly seeking to dismiss the emotional distress claims asserted against them. So it was actually like 6 claims they were trying to dismiss. For the foregoing reasons, the defendant's motions are allowed as to the negligent infliction of emotional distress claim asserted by Kaylee, and denied as to Kaylee's claims for reckless and or intentional infliction of emotional distress, which is weird because that's the higher standard, but it must mean they're duplicative. The defendant's motions are denied in all other respects. Background. The following facts are drawn from the plaintiff's complaint and accepted as true for purposes of this motion. You should know that this is a 12b6 motion to dismiss. So you read as a judge, I'm not a lawyer, this is not legal advice, you read all the facts in the light most favorable to the moving party. To the initial moving party, to the person who brought the lawsuit, because the moving party there could technically refer to the person who brought the motion, but you read all the facts in the light most favorable to the plaintiff, to the person who brought the original complaint. The court also considers facts contained in matters of public record pursuant to Merrim v. Cobrick Offshore. Oh, so the court can just sua sponte read? Oh, the judge can just read news articles about pursuant to Merrim v. Cobrick Offshore Fund Limited, 442 Mass 43, Pin Site 45, N4, 2004. That's useful. Who knew? You learn something new every day. On January 28, 2022, Reed patronized C.F. McCarthy's from 8:51 p.m. through 10:29 p.m. She consumed 7 alcoholic drinks during that time frame. Reed then patronized Waterfall from 10:54 that night through 12:10 a.m. the next morning. She consumed 2 alcoholic drinks during that time frame. So they're saying she had 9 drinks in the light most favorable to the plaintiff. Her blood was drawn on January 29, 2022, and testing revealed that her blood alcohol content would have been between 0.13 and 0.29 after leaving Waterfall. Okay, so I think that range got narrowed pursuant to the second trial, but they're really reading the light, and judge is really reading this in the light most favorable to the plaintiff if he's giving them the 0.13 to 0.29 range, because that was the pre-adjusted range. The actual range in the second trial was smaller. Okay. Wait, what? What? What the hell? Is this how it was scanned? This can't be an error. Her blood was drawn on January 29th, and testing revealed that her blood content would have been between 0.13 and 0.29 after leaving Waterfall. This is page 3, right? It just starts, revealed that her blood alcohol content would have been between 0.13 and 0.29 after leaving Waterfall. Okay? During that time frame relevant to the instant lawsuit, Reed and JJ were in a dating relationship. JJ was with Reed that evening, and they had been arguing. Judge is calling him JJ. I guess that's a message to people who said it was inappropriate for JJ to be used in other filings. I mean, Judge is doing it now. JJ was with Reed that evening, and they had been arguing. After leaving Waterfall, Reed got into a motor vehicle with JJ and drove to a residence at 34 Fairview Road in Canton while intoxicated. After arriving at the residence, JJ exited Reed's vehicle. Reed then drove her vehicle and hit JJ. JJ was knocked to the ground, suffering serious injuries that ultimately led to his death. Remember, this is Judge reading the facts in the most favorable light to the plaintiff. This is what Judge is saying is the most favorable light, which is basically what I thought happened. JJ got out of the vehicle, Karen drove and hit JJ. No one's saying she intended to. JJ fell to the ground, and that falling to the ground caused him to suffer injuries, like she said, in effect, the chain of events that caused him to die, the causal chain of events. That's the whole kit and caboodle. Like, Judge is saying, if you read objectively the facts, that's probably what happened, in the light most favorable to the O'Keefes. And that's what I'm saying. That's what I think happened. Like, I don't think she's a murderer, an intentional murderer. I think there was a bad accident, and she just overreacted. She didn't know what to do. How do you want me to condemn her soul? Not because of what happened in the moment, but because of how she reacted. I can't. Not necessarily saying I agree with that not guilty verdict, but because I don't understand how that happened. Maybe because the investigation wasn't good enough, which is becoming a theme with that unit. And maybe she was overcharged. I think that was the consensus as well. If they had just charged her, a lot of commentators were saying the general U, but if they had just charged her with OUI manslaughter, something low, I think they would have got a conviction. They went too high. They didn't need to put murder on the table. Reed fled the scene, and this is where I think Karen runs into her culpability, just in my lay opinion. Like, this is where it started to, like, if she had just called the police, I think this would have been over by now. It would have been over a long time ago. She would have done like 2 months in jail. Reed fled the scene and drove to JJ's residence at 1 Meadows Ave in Canton. At approximately 4:30 a.m. on January 29, 2022, Reed woke up JJ's niece, Kaylee, who lived with JJ. Reed began discussing JJ's death with Kaylee and talked about striking JJ with her vehicle. Kaylee heard defendant Reed say, quote, "JJ never came home. Maybe I did something. Maybe a snowplow hit him. Maybe I had hit him. Maybe I hit him. We were in an argument. Maybe he got hit by a snowplow." And it's damning, but like you gotta respect Kaylee. I'm telling you, that's why it's so damning. You may not like it, but you gotta respect her. Colleen, I would love to learn more about the Ellen Greenberg case. You go ahead and send me a message, my friend, and we can cover it. Complaint, paragraph 150. Reed also called multiple people between 4:30 a.m. and 5 a.m. on January 29, 2022, while in Kaylee's presence. At the time, Reed knew Kaylee was a vulnerable minor who had previously lost both parents and lived with J.J. Well as her surrogate parent. Disability, age, recent hospitalizations, like there's lots of stuff like that make you so particularly vulnerable, and there's serious consequences. If you know somebody like has recently had a medical issue, if you know somebody's disabled, if you know somebody's old, if you know somebody's young, if you know somebody's lost both their parents, if you know somebody just lost a parent, there are things that make someone under this standing, this standard, a particularly vulnerable person. Watch what happens when you get designated particularly vulnerable. It makes it like when you torment someone, whether or not intentionally, in this case it's alleged intentionally, or recklessly, which is the same. The reasonable person knew or should have known it could have resulted in torment. The court really punishes the person who does it, because the presumption is that you should have known. Like, just tormenting them, they're already suffering by existing, and you're making it worse, and the court does not look favorably on it. Reed left JJ's residence at approximately 5:07 a.m. on January 29, 2022. She arrived at 34 Fairview Road at approximately 6:03 a.m. Okay, this is right, but it cuts off. So it's right, but the actual timeline is she leaves JJ's residence at 5:07. She's seen on video heading towards Canton Center at 5:11. She comes out the other side at 5:18. We don't know where she is at 5:23, but it's near Fairview Road. Then at 5:37, 5:37, she gets to Jen McCabe's. She meets up with Kerry Roberts and Jen McCabe's. From 5:37 until like whatever, they drive over to Meadows Ave, where they drop off Karen's car, get in Kerry Roberts' car, and then they leave after Karen stands in John's bedroom while Jen and Kerry run around frantically downstairs. They leave in Kerry's car with Jen in the passenger seat and Karen in the back seat to drive from John's house to Fairview Road, where they arrive after 6:03 a.m. But Judge basically got it. And discovered JJ buried in snow. JJ was pronounced dead at a hospital at 7:50 a.m. At relevant times after 7:50 a.m. on January 29, 2022, Defendant Reed went to the grieving house of JJ, feigned comfort to JJ's family, and used the opportunity to, amongst other things, remove the offending weapon, her vehicle, and or destroy relevant evidence. Complaint, paragraph 47. Wow. So they're saying after Karen got out, so Karen doesn't actually get out of the hospital till like 11 or 12. They're saying that's when she moved to do things that they think were destruction of evidence. Subsequently, over the course of several years, Reed made many public statements. Quote, she knowingly and deliberately changed her story and fabricated a conspiracy knowing the same to be false. She publicly communicated this false narrative, thereby frustrating justice for JJ. Such false narrative caused the plaintiff aggravated emotional distress. Complaint, paragraph 52. Discussion. The defendants argue that the emotional distress claim should be dismissed for multiple reasons. One, distress claims are subsumed by the wrongful death statute. They lose on that. Two, the plaintiff's claimed distress was not contemporaneous with JJ allegedly being struck by Reed's vehicle. Kaylee loses on that. Karen wins on that. Three, there was no extreme or outrageous conduct directed towards the plaintiff that resulted in severe harm. Karen loses on that. And four, Kaylee's claims for emotional distress fail as a matter of law. They split the difference on that. The court will address each of these arguments in turn. Standard of review. This is a learning opportunity. To survive a motion to dismiss for failure to state a claim pursuant to Mass Rule of Civil Procedure 12b-6, a complaint must contain factual allegations plausibly suggesting, not merely consistent with, an entitlement to relief. Inachino is the interpolation of Twombly and Iqbal. The factual allegations, never call it Iqbal, Twombly and Iqbal. The factual allegations must be more than labels and conclusions and raise a right to relief above the speculative level. Inachino. In assessing a complaint under 12b-6, the court accepts as true the well-pleaded factual allegations in the complaint and draws all reasonable inferences in the claimant's favor. It's claimant instead of movement. Fairhaven Housing v. Commonwealth. The extent of the court's review is generally limited to the factual allegations in the complaint and any facts contained in the attached exhibit. However, the court may also consider matters of public record, items in the record of the case, and documents cited and relied upon in the complaint. Shire v. Brandeis University. Wrongful death statute and emotional distress claim. The defendants argue that the plaintiff's emotional distress claims are subsumed by the Massachusetts wrongful death statute, GLC 229, Section 2. Among other provisions, the statute identifies the following as recoverable damages: the fair monetary value of the decedent to the person entitled to receive the damages recovered as provided in Section 1, including but not limited to compensation for the loss of the reasonably expected net income, services, protection, care, assistance, society, companionship, comfort, guidance, counsel, and advice of the decedent to the persons entitled to the damages recovered. GLC 229, Section 2. Thus, the wrongful death statute contemplates some degree of emotional distress arising from a decedent's death. It addresses the loss of care, assistance, companionship, comfort, guidance, counsel, and advice, all of which go to the relationship between a decedent and individuals pursuing claims under the statute. The defendants argue that the independent emotional distress claims asserted by the plaintiffs are redundant to the plaintiff's wrongful death assertions and consequently should be dismissed. They lose on this. This argument is inconsistent with established Massachusetts case law. In Ciamino v. Milford Keg Incorporated, 385 Mass. 323, 1982, the SJC held the defendant's argument that the plaintiff's claim for emotional distress is preempted by the wrongful death action misconstrues the common law cause of action for emotional distress. Emotional distress, as the concept has evolved in this Commonwealth, is a severe psychological shock directly resulting from experiencing or witnessing the effects of a defendant's conduct. A claim for damages based on emotional distress does not include an administrator's claim for loss of consortium, which will be present in every wrongful death action such as this. Since emotional distress is a wrong to the plaintiff distinct from that done to the decedent and the statutory beneficiaries of the decedent, it is not a duplicative remedy and is not preempted by the wrongful death statute. So that's why Karen lost on that. Here, the plaintiff's direct emotional distress claims go beyond the mere fact that JJ died. Instead, they point to the alleged wrongs they suffered in their individual capacities. They aver that they suffered such harm in observing JJ just after his death, having Reed attend family events in the immediate aftermath of JJ's death, and Reed developing a public and false narrative that frustrated justice for JJ. These claims are separate from JJ's death and instead are specific to the distress the plaintiffs assert in their individual capacities rather than their status as relatives of JJ pursuant to the wrongful death statute. Therefore, the defendant's motions are denied as to their arguments regarding emotional distress and the wrongful death statute. C. Negligent infliction of emotional distress. The defendants argue that none of the plaintiffs have actionable claims for negligent infliction of emotional distress because their alleged distress did not occur contemporaneously with the accident giving rise to JJ's death. This argument is inconsistent. Oh, so Karen loses this. I thought she won part of this. Is inconsistent with established Massachusetts case law. In Stockdale v. Bird and Son, Inc., 399 Mass. 249, 87, the SJC stated, in Dizanowski v. Benabow, 375 Mass. 555, 568, 1978, we held that Quote, allegations concerning a parent who sustained substantial physical harm as a result of severe mental distress over some peril or harm to his minor child caused by the defendant's negligence state a claim for which relief might be granted where the parent either witnesses the accident or soon comes on the scene while the child is still there. 2 years later, in Freddie v. Daniel O'Connell Sons, 381 Mass. 507-518, we held that the wife and children of an employee allegedly injured through his employer's negligence could maintain an action for negligent infliction of emotional distress, even though they first observed the employee in a hospital immediately after the accident. We said that, quote, a plaintiff who rushes onto the accident scene and finds a loved one injured has no greater entitlement to compensation for that shock than a plaintiff who rushes instead to the hospital. So long as the shock follows closely on the heels of the accident, the two types of injury are equally foreseeable. So that's saying because it's foreseeable that a person who's injured would have their family rushed to either the accident scene or the hospital, you can get a NEID claim or an IED claim out of it. Thus, a family member is entitled to emotional distress damages when they either witness the decedent's actual injury or, quote, come upon the injured kin promptly after the injury. Nancy P. v. D. Amato, 401 Mass. 516-520-1988. The plaintiffs allege that Reed discovered JJ buried in the snow at approximately 6:03 a.m. on 1/29/2022, and he was subsequently pronounced dead at a hospital at 7:50 a.m. that day. Miss O'Keefe, Mr. O'Keefe, and Paul each aver that they learned of JJ's admission to, they blank out Good Sam Hospital because the name isn't Good Sam anymore. I think it had to change because of a ownership rule, to blank hospital immediately and came upon JJ's body at the hospital shortly thereafter. Complaint, paragraphs 82, 88, 95, 102, 109, 116, 123, 131, and 139. Against this backdrop, the complaint alleges sufficient facts that JJ's parents and brother arrived promptly at the hospital upon learning of JJ's death and thus have actionable claims for NEID. Negligent infliction of emotional distress. Kaylee's negligent infliction of emotional distress claim stands on different footing. However, she alleges that she learned of JJ's death or injury when defendant Reed woke Kaylee up at approximately 4:30 on 1/29/22, paragraph 147. Further, Kaylee alleges that she heard defendant Reed say, JJ never came home, maybe I did something, maybe a snowplow hit him, maybe I hit him, maybe I hit him, we were in an argument, maybe he got hit by a snowplow. Complaint, paragraph 150. Lastly, Kaylee states that as a result of Reed's conversations in her presence, she perceived the injuries caused to her guardian, Uncle JJ, and perceived the injury-producing event. Complaint, paragraph 151. Taken together, the complaint does not allege that Kaylee learned of JJ's death or injury at 4:30, but instead learned he was maybe injured at that time. There are also no averments regarding when and the circumstances under which Kaylee first observed the deceased JJ. Oh, she didn't go to the hospital. Her averments concern her perception of JJ's injuries rather than her actual observations. The case law cited by the parties addresses scenarios whereby a family member has observed another family member actually being injured or otherwise suffering shock after promptly encountering the injured family member. Kaylee cannot make this showing. If she had gone to the hospital, she would have been able to. In making this assessment, which I'm not saying she should have, but that was the difference here. In making this assessment, the court acknowledges the following case law cited in the plaintiff's opposition. Quote, the determination whether there should be liability for the injury sustained depends on a number of factors such as where, when, and how the injury to the third person entered into the consciousness of the claimant, and what degree there was a familial or other relationship between the claimant and the third person. Such language is inopposite here. So it cuts against the O'Keefe argument. As the Dinozowski court's decision turned on liability for negligent infliction of emotional distress and the parameters for when a family member arrived at the scene of an accident giving rise to a relative's injury. Stockdale extended the scope of Dinozowski to family members who promptly arrive at a hospital. Neither of these cases, nor any other cases provided by the parties, creates authority to find negligent infliction of emotional distress for family members who learn of a death beyond this prompt time frame. So Kaylee was told it's possible, but that's not enough to give rise to this specific claim. We find Kaylee's other emotional distress claims stand, but for this one, she didn't go to the hospital and she only thought, she didn't know John was dead. She had an idea he might be dead. That's not enough. That's the court, and the court's just applying the law. Thus, Dinozowski's language about when JJ's injury entered into the consciousness of the claimant does not support Kaylee's claim for negligent infliction of emotional distress. Therefore, the defendant's motions are denied as to Miss O'Keefe, Mr. O'Keefe, and Paul's claims for negligent infliction of emotional distress. So Karen's motion to dismiss is denied as to that, so the O'Keefes win. Karen wins, the O'Keefes lose on Kaylee's claim for negligent infliction of emotional distress on that specific issue alone. Now, the reckless infliction of emotional distress. The defendants argue that none of the plaintiffs have actionable claims for reckless infliction of emotional distress because there was no extreme or outrageous conduct directed towards them that resulted in severe harm. That's Karen's argument. In the context of such claims, conduct is, quote, extreme and outrageous if it, quote, goes beyond all bounds of decency and is regarded as atrocious and utterly intolerable in a civilized community. Quotations omitted. Roman v. Trustees of Tufts College, 461 Mass. 707-718. The standard of extreme and outrageous conduct is a high bar. Such conduct means more than workaday insults, annoyances, or even threats and petty oppressions. It means, for example, a high order of reckless, ruthless, or deliberate malevolence that is simply intolerable. Conway v. Smerling, 37 Mass. Appellate Court, 1, page 8. So page 1 is where it starts. Page 8 is the pin site, 1994. The plaintiffs allege that Reed developed a narrative surrounding JJ's death, which caused them to suffer emotional distress. In support of their opposition to the instant motions, they have produced a search warrant affidavit, which is a matter of public record, that the court may consider in assessing whether the complaint plausibly suggests an entitlement to relief. All right. Under our common law, judicial records are presumptively available to the public. When filed in court, search warrant materials are judicial records to which the public's presumptive right of access applies once the warrant has been returned. Thus, once the warrant is returned, it becomes a public document and may be considered by a court when ruling upon a motion to dismiss. Shayer, 432 Mass. 477. All right. So, good to know. According to the search warrant materials, on January 22, 2024, Detective Lieutenant Brian Tully of the Mass State Police applied for a warrant to seize, quote, any mobile device capable of communicating and cell phones used by Karen Reed. 9. The court acknowledges that the substance of the search warrant affidavit is highly disputed. The court's references to such affidavit are viewed through the lens of 12b-6, which requires the court to view facts and draw inferences in the plaintiff's favor. There you go. So we're reading... all the stuff the judge is saying here is all in the light most favorable to the O'Keefes. He filed a return of the search warrant, Tully, on January 24, 2024. Tully submitted an affidavit in support of the search warrant application. The affidavit comprises 31 pages and discusses Reed's communication regarding JJ's death. Briefly stated, the affidavit largely describes actions by a local blogger, Aidan Kearney, who runs a series of social media websites under the name Turtle Boy. The affidavit states that Kearney posted articles on social media accounts that reflected personal attacks on civilian witnesses, members of their family, and their friends. The affidavit also states that throughout various postings and videos, Kearney identified several individuals who socialized with JJ and Reed, stated that they, not Reed, were responsible for JJ's murder, and encouraged his social media followers to contact and harass these individuals. Additionally, the affidavit references certain comments Kearney directed to the O'Keefe family. Quote, how much slack are we supposed to give you, John O'Keefe's family? The time period for the grief, whatever, that we are giving you, like, we are not going after you because of the grief. That is expired. It's expired because you're trying to send an innocent woman to jail for the rest of her life. I don't feel bad for you anymore. That's what the court quotes Kearney as saying. Plaintiff's opposition, Exhibit A, paragraph 39. Per the affidavit, Reed communicated with Kearney through an intermediary, Natalie Winnicke Berschneider. Through this intermediary, Reed gave Kearney information concerning her case, some of which was potentially not available to the public, which Kearney then used in his social media postings. Reed also shared personal information and pictures of many civilian individuals for whom Kearney argued were responsible for JJ's death. When applying the plausibility standard required by Rule 12b-6, such actions are consistent with the plaintiff's averments that Reed developed a narrative surrounding JJ's death. Footnote 10. In making this assessment, the court is not ruling on whether Reed's narrative was true or false. As with its consideration of the search warrant affidavit, the court is exercising its legal authority regarding the instant motions, which is limited to applying a plausibility standard with facts and inferences viewed in the plaintiff's favor. 12b-6 is the plausibility standard. That's another way of saying 12b-6. Kearney unquestionably took extensive efforts bro, unquestionably, that's a little bit more than reading it in the plaintiff's favor. That's judge making a point. This judge doesn't like Aiden. Kearney unquestionably took extensive efforts in publicizing information regarding the charges against Reed, and the affidavit describes Reed acting in concert with some of those efforts. Notably, Kearney stated that the time had, quote, expired for, quote, going after the O'Keefe family, and that the O'Keefe family was involved in a cover-up regarding JJ's death. Wow, so Aiden's words are being used against Karen. This is also why she's pissed. That's my opinion. Taken as a whole, in applying the plausibility standard, the complaint and this Warren affidavit set forth sufficient facts that the extensive media attention perpetuated after JJ's death caused the plaintiffs to suffer emotional distress. Well, I think I figured out what was going on. Wow. Wow. They were building the civil case too. Jesus Christ. That's some shit. That's some shit, huh? I don't even know what to say about that. That makes sense why only Tully testified at the March 27, 2024 grand jury, and they didn't have Lindsay testify, or Natalie. Oh my God. It was just to build the civil case. Well, not just. It was also to put pressure on Aiden, I think. But they were building the civil case. Tully was... Look at Tully built half this civil case. I mean, yeah, it was Aiden's words, but Tully built half this case. And yeah, you could argue, of course, they were going to use it, but come on. Come on, they're not even going to get to search her phones. 585 days. That means the only thing that search warrant affidavit did was create a public record. And the only thing it ended up being used for was to help the civil suit. That's ruthless. Just something about how they took advantage of Lindsay. It really, really upsets me. And I can't let that cloud my judgment. I have to make policy decisions. And I can't. But that part just breaks my heart. Alright. Let's finish this up. I just can't believe it. Primarily, the defendant's motion set forth generalized legal statements for extreme and outrageous conduct. As to a substantive argument, Reed cites to Polloy v. McMahon, 468 Mass. 379, 2014, Polloy is arguably similar because it dealt with 1, filing false police reports and harassment prevention petitions against the plaintiff, 2, verbally attacking the plaintiff, and 3, monitoring and recording the plaintiff's home. Those are torts? Wow. Whoa. Those are torts, huh? That's the remedy? Okay. Okay. Huh. The SJC in Polay held that such action did not rise to the level of extreme and outrageous conduct. Huh. Oh, okay. The court acknowledges that Polay shares parallels as to a dispute between individuals which escalates into allegedly harassing behavior. However, given the extensive scope of media scrutiny and its relationship with Kearney as alleged in the complainant's search warrant affidavit, the facts of this case rise above those at issue in Polay because of their public and pervasive nature. Oh, so doing this kind of thing in without drawing publicity to it might not rise to the level of an actionable tort, but it rises here because of how public it was. Okay. Therefore, the defendant's motions, so Karen loses, are denied as to the arguments regarding extreme and outrageous conduct. Claims asserted by Kaylee Furbush. The defendant, paragraph E. The defendants argue that the complaint does not assert sufficient facts that Kaylee suffered emotional distress, and that it does not describe which conduct applies to which claim. As discussed above, Kaylee's claim for negligent infliction of emotional distress must be dismissed for failure to state a viable claim. However, consistent with Miss O'Keefe, Mr. O'Keefe, and Paul's claims, Kaylee was also plausibly distressed by the public and pervasive nature of Reed's alleged false narrative. Okay, so she wasn't really targeted with it, but she was impacted by the narrative. I agree with that. The alleged fact, I didn't really give as much weight to that as I should have, but I agree with the judge here. The alleged facts surrounding Kaylee's interactions with Reed in the early morning hours of 1/29/2022 can also be plausibly characterized as extreme and outrageous. Such determination supports Kaylee's claim for reckless infliction of emotional distress. Kaylee is the only plaintiff who asserted a claim for intentional infliction of emotional distress. A claim for intentional infliction of emotional distress requires sufficient averments that Reed intended to inflict emotional distress or that she knew or should have known that emotional distress was likely the result of her conduct. It's actually a reasonable person. It might be a reasonable person, but anyway. With reference to the specific allegations of the complaint, Reed's motion states that the defendants questioning what happened during a phone call with third parties, even if in Kaylee Furbush's presence, is also not actionable conduct. This does not convey the full scope of what occurred during the early morning hours of 1/29/2022 in the manner alleged in the complaint. Instead, the complaint plausibly pleads that Reed made multiple distressing calls about JJ's physical condition, namely being struck by Reed's vehicle or by a snowplow. Moreover, Reed made these statements upon waking Kaylee at 4:30 a.m., which plausibly contributed to the distressing nature of that interaction. Even if this court were to accept Reed's position that she was merely engaging in telephone conversations, conduct otherwise reasonable may become tortuous when directed at an individual known to be particularly susceptible to infliction of emotional distress. Boyle v. Blank. At the time of this interaction, it can be inferred that Reed knew Kaylee was a vulnerable minor who previously lost both parents and lived with JJ as her surrogate parent. Given such status, Kaylee would be particularly vulnerable to distress caused by an additional loss of a parental figure. Thus, based upon Kaylee's vulnerability and susceptibility, Reed, at a minimum, knew or should have known that her conduct would cause Kaylee to suffer emotional distress. This plausibly supports a claim for intentional infliction of emotional distress. Therefore, the defendant's motion to dismiss are denied as to their arguments regarding the sufficiency of Kaylee's claims. Okay, so there you go. You can kind of see exactly how that kind of plays out. Kaylee can't claim the negligent infliction of emotional distress because she didn't see John in the hospital or after he was hit, but she can claim intentional infliction of emotional distress because although Karen's actions weren't on their own tortuous per se, the impact on Kaylee, who Karen knew or should have known was particularly vulnerable, becomes tortuous, even though it's otherwise not. That's intense. I didn't realize that was the standard. I'm not a judge. That was a judge. I'm not a lawyer either. I'm just reading the order. All right? None of this is legal advice. posting that an email. Oh, I saw that, Lisa. Apparently, DePietro is. So this is very interesting. Aiden is claiming. I'm just reading the comments. I haven't had time to fully run this over. I did get a link earlier that someone was, I think, posted on social media. Aiden Kearney is alleging that John DePietro got catfished by a fake media producer for Hank Brennan. John DePietro is saying that was not actually John DePietro and that this is fake. So maybe Aiden got catfished by a fake John DePietro, or one of Aiden's followers thought they were catfishing John DePietro, but that was a fake John DePietro catfishing them. Oh goodness, we have a metaphysical catfish. Oh no. Listen, I am equipped to handle a lot of stuff. I don't know. I just walked into a metaphysical catfish situation. We're going a little beyond Towel's ability to explicate this here. Are you telling me John DePietro is denying that he was the person who got catfished? So it's very, very possible. It's very possible that someone was trying to catfish John DePietro, but the catfish got catfished by someone pretending to be John DePietro. It was a reverse catfish, because now the catfish looks like an idiot. You got... Oh, this would be brilliant. Oh, ladies and gentlemen, this is how you write a good novel. You know what I'm saying? Imagine it's a reverse catfish. Listen, this whole thing is so absurd that honestly I would 100%, I'm not even going to lose it, I would just buy it if somebody pretended to be John DePietro and then someone trying to catfish the real John DePietro got catfished by the fake John DePietro. Oh, isn't that just the greatest thing you've ever heard? A reverse catfish. Oh, ladies and gentlemen, we have entered the world of metaphysical catfishing. Listen, something new every day with all of you. I would just like to say, every single day, listen, I don't know how we've gotten to this point. I feel like my life is a theater of the absurd, and, well, then again, I am a towel. You are all towels. I really should expect this kind of thing, but I would just like to point out this is a ridiculous, if this is actually the reality, okay, I just want to put this all together for you. I just want us all to be on the same page. Someone who was pretending to be Hank Brennan's media agent reached out to someone they thought was John DePietro. Now, the reason they were pretending to be Hank Brennan's media agent was to catfish John DePietro. However, it's very possible, according to John DePietro's denial, that they did not actually reach the actual John DePietro. They reached a fake John DePietro who was catfishing them into contacting that person and then pretending to be John DePietro. It's like when you call Domino's and you call Pizza Hut and you put them on the phone with each other and they try to order from each other. That's what that is like, to understand. That is the greatest thing I've ever heard of in my entire life. You don't understand, ladies and gentlemen. That's absolutely unbelievable. Okay? And I just want to say that would be great. All right. Now, my name's Grant Smith Ellis. We'll spend more time with each other very soon. I am going to see you all on Thursday, Massachusetts CCC public meeting. I'm going to be broadcasting that whole thing. So, you know what we're going to do on Thursday? We'll do the chat. All right? I think a lot of you... No, the vote is 50-50 as to whether Karen should get immunity or whether Turtle Boy. How bad did some of you feel having to vote Turtle Boy in order to click the button that said Kate always wins? We need holistic psychology here to yell at me for doing push polling. I bet some of Kate's people felt so guilty having to select Turtle Boy there. Probably like, oh, Grant's doing this to us on purpose. Yes, I absolutely am. I think it's hilarious. But yeah, so what we're going to do is on Thursday, we're going to do the chat. All right. So we'll start before the CCC meeting. I'm going to review my infamous chat. All right. I literally have it here. Let me see. Do I have the chat? I think I have the chat. Wait for the chat. There it is. You want to see the chat? I love the chat. Microdots came in the comments yesterday and was like, I love Grant's charts. Or he was like, I really like Grant's charts. And I was like, damn right, Microdots. I like my charts too. I'm a little towel. Now look at my chat. All right, so this is what we're going to do on, what is it, Thursday. All right, let me just move this little Venmo thing over here. So on Thursday, we're going to do the chat. We're going to start with the chart, then we're going to do the CCC meeting. All right, so I've had a great time with you all today. I'm pretty tired. Haven't been. I think you're becoming sadistic. Little old me. I am not sadistic. I am a little towel. Anyway, we'll start with the chat. All right, on what is it? On Thursday. No stream tomorrow. Got to do towel things, class, etc. Health things. We'll do a stream Thursday for the CCC, but we'll start, if you're up early in the morning, probably sometime after 8 or 9 a.m. Eastern, with my overview of the chat. All right, that is the chat. One chart to rule them all, one chart to be a towel. You need a Q&A, but don't pontificate, rapid fire answers. Okay, just start asking things. I'll stick around for a few minutes. Just start saying things, and I'll see what I have to say. You can just ask me things. Oh, thank you, Julie, craziest person on earth. Great to see you as always, my friend. But yeah, I'll hang out for a second. No interviews. What do you mean? Oh, God bless you, bossy Texas Chicken Bella. But yeah, I'll stick around for 5 minutes. Feel free to post your questions in the chat. We'll do rapid fire. You can ask me about anything. Want to ask me about what I think about the sky? I have theories. I've been researching geological formations and trying to interpolate the Younger Dryas event. So if you want to ask me about that, we can talk about the Younger Dryas. My favorite song... God, my favorite song? What is the apex of human musical achievement? I mean, Dark Side of the Moon as an album, I don't know if there's any specific song that's better than others. I think it's the album as a whole is probably like the best musical achievement. And that's a really good question. I'm very lyrical, so I'm probably partial to something from Dylan. Dylan, I think Talking World War III Blues is probably the best. In terms of like a lyrical exercise, like a song to Woody is probably like his like best work. But like, I don't know what my favorite song is. It's very mood dependent. I'll keep looking at the comments. Oh, you meant Thursday. Oh, that's okay. Do you think the Karen Reed audio is authentic? Said Peggy. Yes. I think the way Karen's been acting, it's definitely authentic. Has anyone heard from Harvard Yard? Yes, I got a message from Harvard Yard like a week ago. They were doing good. Jew Drops, I heard, has showed up on Bossy Texas Chicks channel within the last few months. I hope Jew Drops is doing well. We love Super Towel at Jew Drops. And you got to remember, folks, that Karen Reed trial was hard on a lot of people. That was 6 weeks of a lot, and that was hard on people. So, Anthony Barton, it was great to see you, my friend. You got a few more minutes of me. I'll give you a few more minutes of questions. Anything you want to ask, we can talk about. But on the whole, I'm getting ready to go to bed. Grant, not only did I invent trivia for your show, I think rapid-fire questions should become a staple part of the show. Sure! The more questions, the merrier. I think we actually should ask Tal more questions, because I have a lot to say, but oftentimes I look for questions about what I'm talking about. I'd rather just answer your hodgepodge questions. Maybe you want to know things. Yeah, at the end of the stream. Maybe you want to know things about me. This is when you can ask them. Ever wanted to learn about Little Towel? Christina is making pronouncements. But yes, whether or not we have more questions, it takes like 30 seconds to get the questions up anyway. Indictment Watch. Oh, I think people are on Indictment Watch. It was good to see you, Christina. Bossy Texas Chick. Anthony Barton. Troy. Julie, craziest person on earth. It was great to see you, my dear friend. Beach Nance, Lisa C, Just Jim, it was great to see you. Troy, thank you for being with us, my friend. Peggy, it was great to see you. Anthony Barton, the Super Towel themselves. Bossy, Texas Chicken, Bella, it was great to see you both. I don't understand why people don't love you. I do, like I do as a friend. Well, Anthony, I think it's because people have political loyalties or personal loyalties or whatever, and, you know, I don't take it personal. Just Jim, it was great to see you. Thank you again, Julie, craziest person on earth. Grant Smith Ellis says, Bossy Texas Chicken Bella, with your new outlook, do you think Jen McCabe is as innocent as she claims? Yeah, I don't think she did anything wrong with John's death. I just think she didn't like the public eye on her. She got a little desperate. She couldn't do anything about it. And so she asked Kate Peter, in my opinion, how to make it go away. And Kate, I believe, said, just find someone else for them to focus their attention on. And that's why I find what they did, in my opinion, to be distasteful. If that's indeed what they did. Since I'm new to you, says Just Jim, why do you call yourself a towel? Well, Just Jim, back in January of 2024, someone said to me that I call myself a towel, so they thought my pronouns were towel. It was like some user on the YouTube chat, actually, named Stoop the Kid. And I was like, okay, I'll just run with it. So I became the towel from South Park on Twitter, and then it became a whole thing. Now we have towelettes, washcloths, paper towels, hemp towels, beach towels, microfiber towels, soap dispensers. There's a whole towel universe. It's really fun. I agree with you, Bossy Texas Chickabella. I agree. I think Jen McCabe just aligned with the wrong person when what she really needed was someone to humanize her so that the Turtle Riders would just leave her alone. She didn't do anything wrong. She just was combative, I believe, instead of, like, humanizing. Peggy says, Grant, why did nobody leaving the Albert's house see a body or John's body? Well, first of all, there is, if you remember the trial testimony, Julie Nagel or someone saw something on the ground. Only a few people really left while it was still like not snowing that hard. And I believe that was Julie Nagel or Ryan Nagel, and it wasn't even Julie Nagel leaving. I think it was one of the passengers in the car that came to pick Julie Nagel up that didn't end up picking Julie Nagel up because Ryan Nagel just pulled up and then left Julie Nagel there, and then Julie Nagel went home later with Matt and Jen McCabe. So the only time you really had someone who had a good view when it wasn't snowing that hard was that first car. And as you remember, they were pulling up when John was still at in the car. So they didn't really see anything. But then someone later, I forget who came to pick who up, says there was a black blob they remember seeing. It wasn't necessarily John's body. They saw a black blob. It was only one witness, and it was either in the car. It was like either in that car that came to pick up Julie Nagel or just a little bit after that. Then you don't have anyone else really leaving until a little bit later at night when it's like 1:30 or whatever in the morning. I don't remember the exact time. And then it's snowing, and then it's dark. And then, of course, like if you think about what the house looks like. So say the house is behind me. There's two doors, if I recall, like one over by the garage and one at the front of the house. No matter what way you walk out, you go diagonally, not towards the flagpole where John was. You go diagonally the other way to your car, to the driveway. So it's snowing, it's a blizzard, it's 2 a.m, it's dark. That isn't ever anything that raised my suspicion. It actually makes more sense that you wouldn't see something that you're not looking for. Just Jim, I'd be happy to play that intro. Freebird says, Grant, does what you think about the sky have anything to do with what people call the great power of the universe? I wasn't actually thinking about that. I'll tell you what I was thinking about, Freebird. So, I've been thinking a lot about Einstein's theory of relativity, and in particular, I think it's called the Fermi paradox. There's this very weird paradox about if you accelerate, just to use very simple terms, if you accelerate at 1g, which is 9.8 meters per second consistently, after about I'd say 2 years or 3 years, you're going to be traveling at 104% of the speed of light, which is not possible. You can't actually travel faster than the speed of light. So I've been thinking a lot about two things. One, what does it mean for the concept of anti-aging that we could just send people up in spaceships and have them go really, really fucking fast in a circle, not necessarily to a specific place out in the universe, but in a circle, which would in effect contract space-time and have their bodies in their molecular structure age at a slower rate than time going on Earth. So, for example, if we sent them up in this quantum loop at say we had them accelerating at 9.8 meters per second, if we had them up there in the sky going around our planet in a circle for 3 years, using that as an example, only 2 years would, only 2 years would have passed on the spaceship, while 3 years would have passed on Earth. I think that's the secret to anti-aging. I don't exactly know how we're going to implement this. We just have to figure out a way to propel people really fast, send them around in a circle, and that's how to stop the aging process. So that's one thing I've been thinking about in my free time. The other thing that I've been thinking about in the sky is, so I'm somewhat convinced we live underwater. And the reason why, not literally underwater, but we live in a form of water compared to the universe is, if you think about an object hitting our atmosphere, it's akin to hitting a layer of water that's 10 meters or 30 feet thick. And therefore, based on the composition of our atmosphere, I think our air is just, for someone who, or some entity that wasn't from our planet, I think our air is just another form of water and we don't really realize it. And so we kind of live in this atmosphere that is a just gaseous form of water for most entities that would come interact with us. So anyway, that's what I think about the sky. I wasn't necessarily thinking about God when I was thinking about it, although I think that plays a role in it all. I was more thinking about just how we can weaponize, not really weaponize, but how we can harness the contraction of space-time at very high speeds for the purposes of anti-aging. And then also I was thinking about the density of our atmosphere. So I'm not really sure what exactly that has to do with anything, but that's what I've been thinking about in the mornings. If you're wondering what does Towel get up and think about, mostly that. I really am trying to think about this anti-aging thing. I'm not really sure we have any type of propulsion mechanism that actually can generate acceleration of consistent speeds of 1g per second, or 1g, I think it's 1g in general, which is 9.8 meters per second. But if we can just, we have things that can go 1g, obviously, accelerate at 1g, but it's a very small amount of time they can do it. We need a perpetual acceleration. We need a form of nuclear fuel that can be condensed into a very small space and facilitate 1g acceleration consistently for 3 to 5 years. If we can pull that off, we can reverse the aging process. Everybody on the same page? Oh, thank you, Freebird. Freebird says, thank you. I find your mind very intriguing. I never thought of that. Very interesting. You're definitely a deep thinker. Love it. Jeff Peso says, does the towel eat breakfast? I have wondered about this. Nope. I get up at about 3 or 4 a.m., if you're wondering how. I try to go to bed around 6 or 7 p.m. Eastern. Doesn't always happen. I get up at about 3 or 4 a.m. The first things that I like to do is I like to read Le Monde, which is the French paper, El País, which is the Spanish paper. I read the New York Times. I read the Guardian. I read the Boston Globe, and then I check the Nippon Index, the Japan stock market. I read New Hong Kong. I read the South China Daily Post. And then it's 3:30. I start checking in on what's going on in the Strait of Hormuz, Yemen, Lebanon, South Lebanon in particular, with the border of Israel. So I'm kind of getting up in the morning. I'm not really eating. I'm digesting a bunch of information because I need to be briefed. I need to know what's going on in every country, and I like to understand what the governments of those countries are thinking. So I'm not really eating. I'm consuming information. Then I have like a coffee with an espresso, and that's like by 4:30 a.m. Then I can look at the European markets. So by like 5 or 6 a.m., I know what the Asian markets are doing. I know what the European markets are doing. I know what the governments of Europe are thinking. I know what the Asian governments are thinking. I know what the governments in the Middle East are doing. I understand if there's any breaking crises happening, and then it's not even opening bell at the NASDAQ or the S&P, and it's like 8 a.m., and I'm ready for the Eastern time news cycle, and then I just chase the news as it goes from like the U.S. Eastern time to the Mountain time to the Western time and do it again. So I don't really eat. I just chase the morning news cycle. That's my food. What? I don't know. Peggy, I'm more interested in the news cycle. Lisa says, I go to bed at 9 a.m. and sleep until 2 p.m. How do I reset my circadian rhythm? Well, I'm not a doctor, and I can't give advice on that. How I would do that. So I used to work the overnight shift at a library. I was a supervisor in university and grad school. And I worked till like 3. And I think the way I reset my sleep schedule was, I think that's what got me on the 6 p.m. like sleep schedule. I just started like going to bed at like 6 or 7 p.m. I'm not saying you're going to be able to pull that off, but yeah, I think I just picked a new sleep cycle and just set myself on it. Who said they missed towel trivia? Oh, Jeff, definitely this weekend. For those of you who are new to this stream, we also play trivia from time to time, and that's really fun. But let me keep going through and saying hi to people. LA Connection was here. It was great to see you. Beach Nance, God bless you, my dear friend. Thank you for stopping by. Oh, so many of you are hanging out. You guys are having vociferous discussions. Carol Ann, thank you so much for watching, my dear friend, and thank you for rewinding. You'll all be able to watch that as well. Hi, Pertinent. It's great to see you. I'm so sorry I missed you in the comments earlier. I'm so glad I saw you on the scroll back. You tune in anytime, my friend. It was so great to see you. Christine, thank you so much for tuning in. I appreciate you so much. It was great to see you, and I love your butterfly emojis. Colleen, Henry, and Buck Towel, the ever-vigilant guardian of the American Midwest. God bless both of you, my friends. Peggy Towel, you've been here a while. It was great to see you as well. Bossy Texas Chicken Bella were hanging out, getting into vociferous debates. Freebird, thank you so much. I appreciate that. And Jamie Doga, thanks very much for stopping by. Keep coming by. We'll be happy to rent you up soon enough. A lot of towel friends in the Blue Wall of Justice today. Kathy McCarthy, thank you very much. Nanya was here earlier talking with Kathy. It was great to see both of you. Meredith, who is not Meredith O'Neill. They want us to all know that. They assert that multiple times per stream. It was great to see you, Meredith. One time Meredith just proclaimed, she was like, I am not Meredith O'Neill. I do not love Turtle Boy. And I think she clarified, she was like, I did not love Turtle Boy. I am not Meredith O'Neill. Who else did I see hanging out today? Oh, Just Jim, you were hanging out, chatting a lot. I appreciate that, my friend. And, of course, Nanya, the captain of the good ship Nanya, was here. Annie, it was great to see you, my dear friend. Annie, we got to find a reason to meet at Cheesecake Factory, if only because Towel doesn't get very nice meals all the time, so. Yes, it was great to hang with you all today. Oh, I am hilarious. I agree. I love the Buck emoji. Buck is in NORAD. You don't understand. Every time I mention Buck Towel, I'm like, why is the man on TV talking? Buck is a dog, by the way. Hold on. Let me get one person who wants to say hi. It's actually Pete Bunny Towel. One second. All right, come on. Get over here. All right, he was napping, but I've woken him up. Pete Bunny Towel has a bed now. I got him a nice little night table that's big enough to be his bed. Oh, God bless you, Freebird. I absolutely will get a ribeye. I haven't had one of those in a while, but great suggestion. And Freebird, if you haven't met one of our official towel mascots, Bossy Texas Chick's cat, Bella, is one of the mascots. We have the Yorkshire, there's a Yorkie Terrier who is one of the mascots. Really, there's like 50 towel mascots. Oh, God bless you, Lisa, as well. This is Pete Bunny Towel. Now, he is also one of the mascots. Now, Pete Bunny Towel, he has a proclivity to just start yelling things. Now, I just want to tell you all, he's a wonderful Pete Bunny Towel, but he gets a little excitable. Isn't that right? He's glaring at me. He says that I judge him. I'm not judging you. You are passionate about the communists. He really doesn't. Listen, Pete Bunny Towel, if you're going to learn one thing, if you haven't met Pete Bunny Towel, he hates the commies, all right? I can't do anything about it. You mention the Soviet Union, and he just starts furiously banging his head off the microphone. It's because we did this whole research project on, like, the commies in the 50s and the 60s and what the U.S. did to, like, prevent them from taking us over. And now Pete Bunny Towel is just, he may as well be Pete Bunny McCarthy Towel. He's just a vociferous anti-communist. Now, I can't blame him. Frankly, he thinks I judge him. He really does, but I don't. I think he's wonderful. And Pete Bunny Towel, the people of the world, in particular Peggy, would like to let you know they love you as well. Peggy says she is Team Pete Bunny Towel. Jeff Bezos says Pete Bunny Towel is glaring at you like the glarer. I think he's becoming a little bit more friendly. He just wants some lettuce. He really appreciates, like, eating lettuce. So, all right, any other words for the people of the world? Pete Bunny Towel. He said he loves you all very much. He appreciates being able to say hello. He would like to go lay down now. All right. You have a good time, Pete Bunny Towel. All right. There he goes. We love Pete Bunny Towel. Is Pete Bunny Towel still courting Toffee Towel? Yep. If Allie and Rue show up when Pete Bunny Towel's here and Toffee Towel's listening, I can't control what Pete Bunny Towel does. He has been trying to court Toffee Towel for like 6 months. I don't know what to tell you. Listen, if you've ever... Courting is hard enough in and of itself. But if you're a stuffed Pete Bunny trying to court an actual bunny, like you're shooting your shot there, you're reaching way above your league, you know what I'm saying? Courtship is a fine art, I think is my point. We need more courtship. I'm a big fan of Jesus, the American family, and courtship. People think it's weird. I don't think it's weird. I don't think it's strange. I think that we should center the American family and courtship. We should normalize courtship. I'm going to create a movement. Forget dating. Forget all that nonsense. Normalize courtship. There we go. There we go. And we'll do it in Pete Bunny Towel's honor. He showed us the way. He showed us the way. All right. So first of all, I just want to say, I want to type this out. God bless you, Freebird. I will 100% try a ribeye, and I am so grateful we got to spend some time together today. Thank you for all of your comments and questions. Also, I am a towel. It's true, I am a towel. Hold on, let me reply to Lisa. Lisa, thank you so much, my friend, for all of your support and comments and messages. I cannot wait to try my next towel cheeseburger, which is on the list after my ribeye. God bless you, my friend. Oh. See, I like to actually type the replies out on stream, you know? I don't know. A lot of I don't put anybody like down, but sometimes people have channels that chat. The chat goes so fast. I like to actually sit and talk to you all, so. God bless you, towel friends. I'm so grateful. Freebird says Grant for president. Oh, I don't know about. How about Pete Bunny Towel for president? Pete Bunny Towel can be president. Buck can be the chief of staff. Colleen Towel can be what is that? The chief of the Unified Command. Listen, I have a plan. Nobody tell Buck Towel. Buck Towel struggles to be noticed as the head of NORAD. If we tell Buck Towel he's going to be the head of the chief of staff, it's going to get a little out of control. Halloween burgers are the best. Jeff Peso says, something needs to be done for Lindsay. I think it's disgusting what the Commonwealth did to her. Oh, speaking of that, Did you know Lindsay has a Substack, by the way? Ladies and gentlemen, you can support Lindsay Gattani not just through her fundraiser now, but if you've been wondering, I'd really like to support Lindsay Gattani, and I want to hear information. I want to hear what she has to say. Well, did you know she has a Substack? I appreciate all of your support that you've been giving me, but did you know that you can support Lindsay Gattani on Substack? She has 609 subscribers. She is the number 59 rising blog on Substack in the entire world, ladies and gentlemen. Lindsay Gattani on her own, just being a Lindsay Gattani. That's what I'm going to start calling her, a Lindsay Gattani. So let me take a look here. Let me show you how to find this Substack. So if you click that link in the chat, all right, you'll be able to go to Lindsay's Substack. Oh, what the hell? No, there we go. I was like, why is it showing this software? Not that it matters, but so this is Lindsay's Substack, okay? If you just go ahead and you go to, what is it, substack.com/@Lindsay Gattani, you're going to see she's a force of nature, ladies and gentlemen, all right? She is number 59 rising in culture in the entire Substack world. God bless her heart. Just Lindsay herself, all right? So go ahead and subscribe to her. There's a free version. There's a paid version. Obviously, please, Lindsay needs the support, so you're able to pay her for the work that she's doing right through that Substack. You don't have to donate through her fundraiser. You can do that too. But if you want to see her post, if you want to help her rise even higher, let's get her to number 1 rising in culture. Lindsay Gattani, ladies and gentlemen, go ahead and check out her Substack. All right. My name's Grant Smith Ellis. It was great to see you. Want me to become Big Towel? Watch this. I could become Big Towel. Watch this. Watch me. Watch me just... Oh, look at me. I'm Big Towel. Oh, I'm a Big Towel. How's everybody doing? Oh, right. That's me. All right. God bless you all. Thank you again for watching. We'll see each other Thursday. My name's Grant Smith Ellis. Let's do our traditional outro. So, thank you so much for supporting the stream, your super chats, your likes, your subscriptions, your chats with each other, your kindness, centering the human, the fact that so many of you care about the values that matter to me, that matters. So, thank you for that. This is a public information service. It's designed to educate, inform, and entertain the wider public, such as to ward off the usurpation of our representative forms of government, and in turn, protect the vulnerable. If you support that mission, there's lots of ways to help, as I mentioned, but more so than anything else. If you benefited from today, if you learned something today, you know exactly what I'm going to say. Look for reasons to pay it forward with small acts of service and kindness. It can be something as simple as donating to homeless veterans. Ladies and gentlemen, I am an American Towel, and let me just tell you right now, there should not be one veteran homeless against their will in the United States of America. Now, a veteran wants to go live out in the woods, we're not going to stop him. But there should not be one veteran homeless against their will in the U.S., or we have failed. We have failed as a society, ladies and gentlemen, and we can do better. So you can donate to help those homeless veterans. We can work to make this country better for those who fought for us and for our freedoms. We can do it together. You can also, though, donate to animal shelters run by veterans. You want to help veterans? Want to help animals? There you go. If you can't find one, you could donate to an animal shelter in general. Everybody loves animals. Towel loves animals. I wish I could have one. My mom's allergic. But I love animals. I want to have a dog one day. I like little Towel dogs. I like cats too. I like cats. They are very friendly. I gel with them. They have personalities. They speak without speaking. I like them. But I want a Towel dog. You know, German Mastiff. Maybe a Newfoundland. I would like one of those doggies. If you're in the UK and you want to help, you can donate to The Big Issue, ladies and gentlemen. That's a way to help populations experiencing homelessness in the UK. God bless you, Lisa C., and thank you, Carol Ann and Just Jim. God bless you all. But yes, ladies and gentlemen, if you're in the UK, The Big Issue, great way to support populations experiencing homelessness. But it doesn't have to be a donation. It can be something as simple as smiling at someone on the street, reaching out to a friend or family member you haven't heard from in a while. Or yes, ladies and gentlemen, it could also be donating 200 tomato plants like Francis Futrell did one time and having them designated honorary towels forevermore in the outro, literally forevermore. Carol Ann's cat's name is Trump. I love it. Please send a picture, Carol Ann. If you're on X, you can send it to me. My name, GrantSmithEllis@gmail. However you want to send it, you send a picture of your cat named Trump. I will put that cat on the screen on Thursday. I promise you. God bless that cat. Towel likes President Trump. But truly, ladies and gentlemen, I believe in that way it's possible for us to change the current realpolitik, which is the issue that all of this centers on, from one focused on preserving, expanding, and demonstrating our power, to instead one focused on preserving, expanding, and demonstrating our capacity to engage in small acts of service rooted in unconditional love. And in that way, I think we'll be able to find our Tau Eudaimonia or Summum Bonum, in the ancient Greek or the Latin respectively, our greatest good, and have those forces ripple outwards, defining a new digital epic with Aquarius the water bearer standing tall and carrying a towel. I believe it's possible because of you all, ladies and gentlemen, and I'm very grateful to be along on this ride with you. Towel Friends on the X, you got a few minutes at the beginning extra, so I'm going to give the Towel Friends on the YouTube a few minutes extra at the end. God bless you. Be well. It's getting past dark where I am, so I hope I didn't take your sunshine away today. Enjoy the rest of your evening. Rest well. God knows I need it. Maybe you do as well. And thank you for spending time with me. Carol Ann, I'll definitely give you that. It is Grant Smith Ellis at Gmail. There you go. And truly, be well. I'll see you Thursday, Towel Friends, and I appreciate all of you for watching over on the X. Thank you so much. My name's Grant Smith Ellis, and until next time, be well. Towel Friends on the YouTube, it's great to see you. It was great to see you today. Thank you for all your support, your chats to each other, to myself. Thank you for fostering a great community here and being so respectful. Means a lot to me. Good night, Peggy. Good night, Towel Friends. Until we see each other on Thursday, just know how much, even in my more dark moments, you make my life better. I hope you found some friends here, or you found camaraderie listening to me. Know that I have, talking with you. And really, can we do anything more as humans to improve the lives of others than offering an ear? I don't think so. My name's Grant Smith Ellis. Towel loves you very much. Until Thursday, friends, I will see you then, and rest your heads tonight, wherever you are in the world, knowing how much brighter you made Towel's day. God bless, friends. I'll see you very soon. From Towel to